Okay, inshallah, first and foremost, Assalamualaikum warahmatullahi wabarakatuh, and a very good morning. So, inshallah, Aisyah, to get the blessing from Allah Subhanahu wa Taala, let us recite Dua Al-Fatihah. A'udzubillahi minasyaitonir rajim. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin. Arrahmanir rahim. Maliki yaumiddin. Iyyaka na'budu wa iyyaka nasta'in. Ihdinas siratal mustaqim. Shiratal ladzina an'amta 'alaihim ghairil maghdubi 'alaihim waladdallin. Amin. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin wassalatu wassalamu ala asyrafil anbiya wal mursalin sayyidina Muhammad wa ala alihi wa sahbihi ajma'in. Allahumma aftah alaina futuhan arifin wa hifdhal mursalin wa ilhamal malaikatil muqarrabin. Rabbi shrah lana sudurana wa yassir lana umurana wa hlul 'uqdatam min alsinatina yafqahu aqwalana. اللهم فقهنا في الدين وعلمنا تأويل واهدنا إلى صراطك المستقيم. اللهم اجعل جمعنا هذا جمعا مرحوما وتفرقنا من بعده تفرقا معصوما. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار. صلى الله على محمد وعلى آله وصحبه بارك وسلم. الحمد لله رب العالمين. Okay, Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to all my fellow colleagues. Thank you very much, TP, organizing this webinar on intellectual property, patent and utility innovation. Thank you so much, Encik Irfan, Mr. Irfan Awang from Patents Worth for being our speaker today. Also to all the participants who joined our webinar today. So my dear brothers and sisters, first I am very, very happy to see we can see that we have 46 participants sharp at 10 o'clock. MashaAllah, this is as indicator to show that our researcher of IIUM are very interested in this topic. As far as I can sense, since the first day I joined TTO in July last year, I can see the numbers of researchers, okay, that have interest, particularly on IP, is increasing. And then, Alhamdulillah, a few weeks ago, we managed to launch our startup policy guidelines, as well as the launching of our startup, or what we call it as a PIDG grant, that is to improve the ecosystem of startups. So with that PIDG grant that has been announced to be capped at 40,000 would be very much helpful for you, particularly if you are planning for startup development. Why is intellectual property is very important? Because number one, it is not only for the MyRA. Yes, MyRA is important because it gives you lots of numbers of publication equivalency and and also to fulfill their requirement as the KPI. Another thing is that I can see the patent and utility innovation is one of the what I call the asset of the university, because this is how the university will invest. And I can also see that there are numbers of patents and utility innovation other than copyrights has been requested through TTO. And I believe that some of us are confused. What are the differences between patent and utility innovation? So because of that reason, we have Mr. Irfan Awang to share with us his thought, his experience, because he is also not only just what I call patent drafter, okay, but patent agent, but also he has brought of experts, particularly in the as the RTTP holder. And another thing, my dear brothers and sisters, you have to understand that whenever the university provide you grant, the university provide you funding to file for patent and utility innovation, I would say that average about 20,000 that we spend to patent as well as the utility innovation. This is including to support for what do you call that, patent search, patent drafting, utility innovation drafting, and so on. So because of that, I highly encourage not only to the lecturer, but also to the postgraduate students, PhD holder, PhD students, or even for the master student, or even if you are the FYP student, if you have any interest and then you can see that there is a potential of commercialization and what you are developing is something that is very novel and it has the capability or the potential to be commercialized, okay, to create money for not only for the university but also to Malaysia. So we are highly encourage you because we have the funding. Every year we provide quite a number, about 100,000 or 200,000 of funding just to support for patent, utility, innovation, trademark, and so on. So take this opportunity. For the coming year, also there will be funding, inshallah, allocated for the patent, utility, innovation, and other intellectual property. So grab this opportunity, and I hope, especially for the postgraduate student, so you have to work together closely with your supervisor, and then you can, inshallah, sooner or later, you can have one of your output from your PhD or masters that can be also included in your thesis is that you also obtain a patent or utility innovation due to your research that you have been embarking for quite some times. So this, I can see that many of my students, I have few PhD and master students, they are very proud to have their patent, the patent that is with their name, following the successful completion of their study. So take this opportunity. We bring you live Mr. Irfan Awang, very well-known person. So please ask as much as possible. Take the opportunity. I myself will ask Encik Irfan, even though I know some of the differences, but still, as the Deputy Director of TTO, I will ask questions. So take this opportunity. This is very valuable. If you say gold is expensive, this is much expensive compared to the gold. So my dear brothers and sisters, take this opportunity, listen carefully, take notes. And with that, I pass back to Aisha.
Thank you, Dr. Hafiz, for the dua and very warm welcome, insightful opening remarks. So may Allah bless our webinar for today, inshallah. So for now, it is my pleasure to introduce our speaker for today, Mr. Irfan Awang, Founder and Chief Executive Officer of Patents International Sdn Bhd. So before we begin, let me brief our speaker's profile. Mr. Irfan holds a strong background as a chemical engineer and has amassed a wealth of experience in the intellectual property field. After working as a process engineer in a large palm oil company, he joined one of Malaysia's most reputable law firms, where he gained invaluable knowledge on IP. His expertise spans across patents, trademarks, industrial designs, copyrights, and much more. Throughout his career, Mr. Irfan has contributed significantly by attending and conducting international conferences, seminars, and IP courses, including JPAA IP Practitioner Bangkok, the International Federation of Intellectual Property Attorneys, Southeast Asia Patents Drafting Course, the Japan Patent Office for Practitioners, specializing in patents and IP innovation special program by Korean Patent Attorneys Association, and jointly organized by University of California, Davis, and Seoul National University. He speaks frequently at seminars and workshops on the subject of patent practice, interpretation on patent claim, patent search, trademark, industrial design, copyright, and other IP topics. He also frequently serves as a panel judge for IP evaluation and business pitching sessions across various universities and corporations. His advice on identifying patentable inventions, drafting patent specifications, managing trademarks and copyrights, and commercializing IP is highly sought after by clients and colleagues alike, making him a key player in helping clients make crucial decisions for product launches in Malaysia and international. Without further ado, let's welcome Mr. Irfan Awang to share his insights with us today. Over to you, Mr. Irfan.
All right, thank you so much, Ms. Aisha, for a very kind introduction. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh to all of you. First and foremost, thank you so much, EM Technologies Dr. Muhammad Hafiz and TTO Office for having us today. I really appreciate the effort of TTO of keeping up with all this IP awareness program to all researchers, postgraduate and students, and all officers at IAUM. It really a very courteous effort, I would say. It's not easy to, coming up with a lot with programs charted throughout the years so that all of us, the researchers, the student, the postgrad, we have benefited from all of this. So the goals, what we are trying to do is, of course, in line and objective with all the IIUM milestone and everything. So I would like also to congratulate the TTO on the successful launching of the the startup policy or guideline for IIUM. It's a huge milestone for the university. I heard it for a while, and then finally it has been successfully launched. Congratulations on that, Dr. Hafiz and team. And I think based on that, the university are moving forward, going into a diverse branches of IP transaction. So whatever the startup, the spirit of the startup will be on the basis of intellectual property. So the topic given today to us was on the IP and specifically on patent and utility innovation. So, and also we received amanah, I would say. There's a few things that we need to cover throughout this webinar. Okay, so the objective of this webinar is so many things that we try to cover within these few hours. And please bear with me. And how we're gonna conduct this will be very casual session. So if you have a coffee with you or you want to go anywhere, just go. But keep this session on lah. Okay. So there are a few things. Number one, of course, we need to cover the type of intellectual property, what the scope of protection. Based on our previous experience, okay, for a person to be able to appreciate the pattern or the unity to innovation, okay, the person usually we need to have to compare. So what are other components in place? So we have trademark, we have industrial design, we have copyright, and we have very huge development in terms of practice, in terms of patenting, in terms of innovation. And very recently, I was involved at MIPO opposition proceeding for patent. So now the patent opposition proceeding is already in place in the Act, but it's time now for the MIPO to enforce the opposition proceeding. So that means that another thing on our plate that we need to care about is on the opposition proceeding. That means whatever patent granted, and then you have a 6 month from there to oppose or to receive any opposition for any interested party. That is a very, very important prosecution method that need to be taken care of for whatever reason. If IIUM's patent or utility innovation is opposed by any interested party, and then definitely we need to reply and we need to defend the patent. So right now we don't have that. The enforcement of the opposition proceeding in Malaysia not yet enforced, but we do have the third-party observation. So we don't have the pre-grant. So what I mentioned earlier on is a post-grant opposition proceeding. So I try to cover that in this, but I don't want to inundate all of you with a lot of unnecessary information yet. But we're going to cover the fundamental part of it first. Okay. So if you have a question on that part later, then we'll try to chip in some information on that. So PatentSuite, the IP boutique firm, we focus solely on intellectual property, and IP-related matters. So IP-related matter means IP valuations, IP commercialization, advisory, consultancy, and whatnot, all related to the IP lah. Okay, and that's why I mentioned about business. When you do a business pitching, especially technology-based startup, so IP is the integral part of the whole business model canvas. So you cannot remove or omit IP from the technology-based startup, because the spirit of the startup is based on the technology, and the transaction that going to be conducted by the startup will be solely on the IP. So that means there are a lot of things that we need to cover, and the transaction of IP is enormous. is unstoppable, I would say. There's so many things. So that's why we have a sister company, okay, called Antares that focus on the training. So Antares team among entrepreneurs, among the new startup based on entrepreneurship and commercialization. So you can go to the website and see lah. So what we are offering, and what are the services that maybe we can work out together. So for today, okay, as I mentioned earlier on, because the topic on patent and utility innovation itself is like on the upstream part, okay, of the IP spectrum. But before we go there, it's really advisable for us to first understand what are the other IP components that might be plugged in together, or that might be stack up together in order for us to go for successful commercialization. So there's no one IP that fit all. So that means even though you have a patent, even though you have a trademark or copyright in industrial design, still other components of IP must be plugged in together, because the one that we are going to propose for commercialization would be the end product or would be the solution. So the solution comprises of many aspects, and that many aspects are coverable or protectable under different IP regimes. So some aspect under trade secret, some aspect under copyright, some aspect under industrial design. So to safeguard things that we have, so we also need to consider all of these things. Okay, maybe your invention hugely or heavily on the patent, but we cannot forego or let go whatever related, the other aspect related to it. So at the end of the day, we want to have a solid protection and foundation for our product, and wherever we go, and we could have always this safety net, and we can use IP as a sword and shield. So the sword and shield methods here are maybe the basic understanding of IP that we need to know. So what is the reason why we file IP? What's the point of having this IP, etc.? Why you need to first file in the first place? Other than, of course, the KPI, other than the deliverable that you promised in the grant, okay? But there are things beyond that. So in order for us to achieve a successful commercialization of our product that we have now, so we have to look beyond that now, beyond the intellectual property. So we file the IP, yeah, it's a pit stop. It's not even a stop lah. It's part and parcel of the journey, and then you still have to continue the journey to your destination. So where is destination? So destination is what? The short-term destination will be to commercialize your product. And how? So how is the use of this patent can help with the commercialization? Okay, how to tap on the advantage of IP, okay, having patent or trademark to be able to commercialize your product or your services. So all of these things, okay, the IP does not just cover the product, it covers the services aspect as well. So you see, the rights conferred by intellectual property is huge. So huge means there's so many things that we can not manipulate, exploit. We can exploit, it's exploitable. So in order for us to exploit things, we must first understand what are the rights given to us. So for example, you have a patent with you. So what can you do with a patent? What rights conferred to you? So what is the best way of using this patent? So what else? Can you make this and this part? But along the road, the upscaling takes place, and then you are required to tune or tweak certain parameters or certain aspect of your product. And would that improvement be covered already in the patent file or in the trademark file, in the design file, or the copyright file? So the checking must be done at all times, okay? And sometimes subconsciously, we are not aware about this thing, but that's the point of having this kind of a webinar, to disseminate the information that even though you have filed a patent now, okay, and down the road, throughout the conversation, especially have a startup, and startup might have a different way of looking at things, and you have your own autonomy, your own authority, you have more freedom to do things at your own way. And bear in mind that you still have to check within the within the scope of protection conferred to you, whether or not you are allowed to do that, or maybe you are producing something that could possibly infringe somebody else's proprietary product or services. So that's a very crucial thing you need to understand. So how to do that? You need to do constant checking, where to check databases. And how to interpret the data is another important thing. Even though you found a piece of document with you, but you must be able to interpret the document properly. Okay, some jargon, some legal jargon, some lingo are very, very what do you call it? Are very confusing. So you have to be careful with that. Okay. So the objective of the webinar today is basically this is IP 101 lah. Okay. IP 101 to introduce the participant to IP regime. So some of you might have attended the similar webinar before, but it's a refresher course. But to those of you who just joined the IP world, so welcome, and take this opportunity to learn. So at the same time, I will learn from your side on what's the concern. But basically, all I can say, the university researchers have the same concern, and then we try to cover during this webinar. Okay, and the second objective is to introduce you to the components of intellectual property. What are they? Okay, all right. So now, as I give the introduction or mukaddimah early on, so where are we heading our direction thought? Okay, so you have your syarikat pemula, or you have your startup. You're going to have your product, you have this and this, you have resources with you, you have all the facilities with you, you have the full loose, your funding, you have the grant, or everything with you. So now it's on your team to move forward. How to move forward? So now you started with research and you're going up and further up, further up. And we are not sure whether we have to stop at point number 7 or maybe the first point or the first pit stop should be enough already for this kind of product. So the extent of the journey of your research, the answer is with you. So nobody can answer that better other than yourself. So that means, for example, you're processing graphene. So at the end of the day, where is this graphene where is the field of the application of this graphene that you produce? So you come out from a plastic bottle, you convert into graphene. And so what's next? So that's a very, very big question whenever we do R&D. So the point here is that, so what is next? Of course, okay, we want to celebrate the successful of our R&D, or our finding, our discovery, but at the same time, okay, we have to keep thinking on what is next. Okay, so people out there are rushing, competing with each other on producing 2030s product. Okay, but not now. What happened is that maybe not maybe some other research universities. Okay, what happened is that we are doing things that maybe dated technology, maybe way back in 2021, 2022. Okay, so we have to keep on doing things that are current. So technology that are current, technology that are in demand, technology that in trend, and also we must think about what's next. So after this kind of technology roll out to the public, what will be the next? What will be the next? So we must all crack our brain to able to anticipate what's going to be next, so that whatever we invent today have a potential use or relevant use in the future, because of given the journey of research R&D 2 to 3 years down the road. Okay, so I hope you understand where I'm coming from. So we are developing a future technology so that the commercialization can still be there at the time of the completion of the technology. Okay, so now what happened is that, okay, so way back, the research journey started in 2020, for example, in 2023, 2022, okay, and down the road 2 years later, and at the point of 2022, you conducted your literature review, you studied this and this, you do some research on this and this, and then you notice that there's a gap. Therefore, you want to address that gap. Remember, that was in 2021, okay? But throughout the journey, you get a grant and everything. Now it's already 2024, coming to 2025. There's a 3 years gap, and then the probability of or the odd of the gap initially found out by you or discovered by you, okay, might be no longer relevant at this point in time, the current time. So how do we keep track with the trend? How do we keep track with the evolutions? The answer is with you. The resources is all with you. So you have to keep checking. So break the bubble. Whenever you are coming out into one research R&D, there will always be a bubble. Okay. And then in order for you to break the bubble, you have to do the reality checking at all time. So whenever you reach a certain point, I would like to emphasize this, the role of the principal researcher, the role of the ketua penyelidik, to make sure that all these things keep checking up at all time and not to stay at the point of the technology 2 years ago. Of course, they need some cut off time to do everything, but we able to catch up with the technology with a simple checking at databases. Regardless whether it's Corpus ke, High Index ke, non-journal ke, pattern databases, Google Patterns ke, Lens ke, regardless, we have to do the checking. So one-time checking might not be enough and you might be blindsided by some other technology. So that's what our observation is. Okay, you are pitching product that was needed 3 years ago in 2024. How is it? How is that going to be able to the product is going to be commercialized now? And probably with 2 years gap, so many things happen already. Okay, so coming back to the agenda of today, we're going to introduce you to intellectual property. This is the overview of IP lah. Okay, so in the simplest word, it is the creation of mind. So whatever the mind can conceive right now, and then you reduce it to something or visualize it to something that can be heard, can be seen. The creations of mind, basically intellectual property. Intellectual because it's coming from here, and property because it's an asset. So now we able to think of, okay, this is the planning, the research strategy that we're going to do. These are the ideas for the startup policy and the guidelines. Okay, these are the, a lot of research journey coming out. This is the methodology we're going to use. This will be the result discussion we're going to use. All of them are intellectual property. Okay, so to protect the intellectual property, IP law regime is introduced. Okay, so we have patent, trademark, industrial design, copyright, geographic indication, layout design of IC, plant variety protection, and trade secret. All of these are components of IP. Okay, so some of you might have a question. So I already filed a trademark for my unmanned aerial vehicle. I already filed a trademark for my graphene. I already filed a trademark for my gelatin capsule. I already filed a trademark for my plant extract. That is so funny. You know why? Because trademark won't be able to protect that product. The nature of the law drafted for trademark won't be able to protect the active compound from a plant. The trademark law won't be able to protect your UAV or UGV or whatever unmanned vehicles. Won't be able to protect that. Okay, so even though you file a trademark in all classes, it won't be able to help you to protect the product itself. Because the nature of patent or the nature of trademark, design, copyright, all of the components listed here are different. They have different jurisdiction from one to another that do not overlap. Okay, so for example, patent protect the functional aspect of your product. So patent/utility innovation or UI protect the functional aspect of your product. The trademark is a name tag, just a brand name. Okay, just a brand name you give to a product, but it won't be able to protect the product. Okay, please clear this misconception we have right now. Even though trademark is less complicated than patent for that particular product or particular technology, even the copyright is way much cheaper or less complicated than patent, but you are actually doing something that is not right. You are doing something that is not relevant. You're not doing justice to the invention that you have come up with. So these are the things that I always emphasize the researcher, the importance of able to identify the IP aspect of your product, and also the reason why you need to have an IP agent or IP counsel with you to be able to point out which aspect of this suitable for what and what. Of course, at the end of the day, the funding or the whatever surplus from your grant will be the deciding factor, but we need to bring justice to this. You know why? Because at the end of the day, the commercialization will take place on the basis of the rights given to the product, the IP rights. That's why they call it IPR. So the IP rights associated with patent is something else. The IP rights associated with trademark law is something else. So even though you have a copyright for internal combustion engine, ICE, it won't be able to protect the ICE. Okay, the ICE, the engine itself, must be protected under patents law. Okay, the nature of copyright. So if I already filed a copyright for my ICE, so it's already protected, what? I'm afraid no, because the one protected by copyright is the piece of manuscript in which the ICE is written down. So you have a write-up on the ICE in the piece of document or manuscript. The copyright protect the reproduction of the manuscript, but not the underlying idea inside the manuscript. Okay, so be clear on that part. Okay, and as much as you want less headache in IP protection, in as much as you want cheaper protection, not cheaper protection, cheaper fee for your IP protection, please don't sabotage your own inventions. You need to give justice to whatever they have done. So find a relevant IP protection for that. And if the needs be, you might need to get some funding, extra funding, additional funding for filing patent, trademark. When we talk about university research works, patent is the most relevant IP component. So I would say safely 80% of university research work are patent protected. Patent protection is the one to go for. Okay, trademark and industrial design and copyright will be lesser than that. So how to determine between of these? Any one of these. This is the reason why we have webinar today. Okay, to be able to point out to identify which component is suitable or which component is relevant to the nature of your invention, the nature of your research. Okay, so some research, okay, might have multiple aspects. So we consider that later. I will introduce some example on the multiplicity of aspect in one product. So does IP protection have a time limit? Ada ke? Adalah. It's like your nasi lemak that you makan earlier on. Cannot be like 2 days ago or 3 days ago, and so here is like it has a timeline, a specific legal life. Okay, so time limit can be shelf life, can be market life, can be legal life. But here when we talk about IP protection, it's a legal life of that technology. So that means what we are looking here is something that limited time of exploitation. So you file a patent in 2023. So what are you waiting for? You file a patent in 2021. Now it's already 2024. So what are you waiting for? You already filed a patent. You already filed a trademark. You already filed a design. You filed a copyright. So what is the reason not to commercialize the technology now? Are you waiting for the patent to be granted, is it? No. There's no provision that restricts you from doing commercialization at the moment after the patent or trademark industry design has been filed. So that could be like a myth lah. It's a myth. It's a myth. So you already can start your commercialization at the moment you file a patent application. So why wait? Why bother waiting? So time and tide wait for no man. So pasang surut just berjalan je. So that means you have to do it right away. That's why I told you earlier on that you have to keep going and think of what's next. So let TTO handle your IP filing and everything. And what you need to worry about is how to commercialize this, how to get the money back, how to get the ROI back, how to get the ROV back. So how to get this thing back within a certain period of time, which is in this case, for example, 20 years for patent. So yeah, of course, the legal life is 20 years, but the market life of your patent or your technology might be shorter. Your shelf life of your product might be shorter than the 20 years. Okay, so what if you have your market life longer than 20 years? And then we have a different strategy. So the question here is that I'm going to pose to all of you, why wait for commercialization? What is the thing that you require? So if the excuse is the patent, waiting for patent to be granted, squash that off. You don't have to wait for patent to be granted. You need a more grant, apply for a grant. You need more money, apply for money. You need more authority, apply for a startup. You need what? So we have answers for all of that. Okay, so we need to find enablers in this case. What enable you to commercialize it? What is next? So you need to have the R&D probably within a timely period going out to the public or to the community, so that whatever you are doing is still current. Okay, so industrial design in this case lasts for 25 years, okay, maximum lah. Okay, trademark indefinite years. Okay, that means as long as you still using the trademark, you can still renew the trademark file at Malaysian IP Office, MIPO, for every 10 years. Selagi mana you guna, you renew lah, you bayar lah. Okay, so for patent, maximum 20 years. Okay, so maybe shorter than that if your patent is revoked or if your patent is invalidated. So bear in mind on that one, moment you file, just do commercialization as you wish. Okay, put the things properly and then execute things. Okay, the copyright, okay, generally life, the protection conferred under the copyright law is generally the life of the author plus 50 years after the death. Okay, it might seem a bit longer, but remember the protection conferred by copyright is not the same as patent. It's not the same as license. It's the same as trademark. I'm not biasing towards other, but for the case in our context now, the university research work is heavily or biasingly related towards the technical aspect, which is patent in industrial design. Even if you're from social sciences, whatnot, copyright might be something that relevant to you lah. Okay, but the SNT, not the SS, so SNT more related towards more this. But sometimes even in social sciences, so there are still technical aspect of it. Okay, so as and when you have example, you just point out in the chat box. We try to pick up later. Okay, so Malaysian IP Office is the IP Office of course, IP Office of Malaysia kan. So there's one and only under KPDN, okay, Kementerian Perdagangan Dalam Negeri. So bear in mind that some requirement for IP, for example, patent, novelty of a patent invention is worldwide novelty. So, but the protection conferred to you as a patent owner, I mean to IIUM as a patent owner, not you. The researcher is just inventor, but the owner in this case, IIUM, would be only limited to Malaysia. So the protection is territorial, but the requirement for patenting, requirement for industrial design is worldwide. Okay, so if you want to enjoy international protection, you need to file in each and every countries in the world. Okay, there's no such thing as international patent application ke international protection for trademark ke international protection for industrial design ke, tak ada. So you still need subject to the country. Takkanlah kita file kat Malaysia, tiba we want to enforce in Singapore. Singapore is a sovereign country. So it's a berdaulatnya country, and Indonesia and Thailand, we still have to go there and file in that particular country and follow whatever regulations and peraturan as stipulated there. So the same thing here. So meaning to say, the law in Singapore might not be laku or valid in Malaysia. So same goes to here. So Malaysian patent law is not valid in other countries. So they might have some similarity, but it's subject to the statute and statutory acts in that country lah. Okay, so again, if you want to go international, there's certain time period. Okay, if you are filing copyright, you file patent in Malaysia, you have certain time period to go outside. Okay, so for example, patent give you 12 months from the filing date of Malaysia patent application or UI patent application to go outside of Malaysia. So you must decide, deliberate and decide and execute the decision within the 12 month. Okay, so that means that you still can have the priority of your early application, and your early application won't be able to kill your patents in other country. All right. So for trademark is 6 months. So you file a trademark in Malaysia, you have 6 months to go outside Malaysia. If you have interest and you have followers and you have funding, or you have counterpart, you have collaborator, or you have partner in that country lah. Okay. But the cost you always can disseminate. So the person in that country, you have to bear the cost. But the trademark owner or the patent owner will be IUM. It's subject to whatever arrangement that you have. Okay. So IP again must be plugged together with commercialization. Commercialization is something else. Okay, something else means that it's not totally alien, but the reason why you have R&D is to put that thing in, to put the technology to the market, to the public, so that the public will benefit from that. And what is the thing happen there? The knowledge will transfer. And if you have some money, royalties and everything, the monetary benefit, that will be the commercialization part of it. So you commercialize technology using an industry, by way of industry, helping this, whatever medium that we have. So I'm not going to talk about commercialization. It's going to be a separate workshop together. Okay. So we're going to focus on IP. So IP can comprise, one product can have many IP. Okay. And not necessarily one. And I emphasize again, there's no one IP blanket that fits all. So that means it's a very specific in nature. So the fact that you have a trademark for a smartphone like this, okay, does not necessarily imply or mean or impose or consider or deem that the whole phone is protected. Some aspect of the phone need to be subjected to different IP protection. So for example, if it is related to something like functional, something a technical character, something that have a technical effect, like it or not, believe it or not, whether you have money or you don't have money, with funding or no funding, patent is the way forward. Patent / utility innovation is the way forward. Okay, so you cannot have a lithium battery protected under copyright law. You cannot have that lithium battery protected under trademark law. You cannot have the phone lithium battery under industrial design because they are not relevant. Yes, you can file. You can file the lithium battery under copyright law. But again, remember, what is the right given by the copyright law? Oh, only to control reproduction of that manuscript. Reproduction, not the reproduction of the lithium battery. Reproduction of the write-up of the manuscript. Berbuih mula I cakap pasal benda ni all over again. I really hope that you understand the concept of having different IP because they're protecting different aspect, a different jurisdiction of your product, different aspect. By looking at this example on the screen, you'll be able to appreciate that, patent is more technical. Yes, correct. Trademark is not the trademark or the name tag. Correct. Copyright, what are the protection given to? The literary work. I give you some example. There's only 6 category of trademark. 6 category of copyright or eligible works to be protected under copyright law in Malaysia. What are those? Okay, stay tuned. We're going to introduce you later. So industrial design, okay, protect the aesthetic part, the one that can that judged by the eye. So our eye can only see the shape of the phone, but we cannot tell the borosilicate screen. We cannot tell the silica amount on the screen or the bendable screen. We cannot tell how the hinge work. We cannot tell how the camera work because that's the limitation of our eye, and that is where the industrial design is. Okay. So one thing I want to share is that there will be a revampation of Industrial Design Act maybe somewhere next year. So we're going to we are going to have a totally new design act. So the industrial design, the term industrial design at the front will be removed. So it's going to be just a design act. Okay, so stay tuned lah. There's a lot of things going on in IP world. Why? Is it because of the effort of Malaysian IP Office? Yes, but most importantly, because Malaysia is a signatory to many bilateral agreement, RCTPP, TRIPS, and everything. Whatever happened now there must be ratified here in Malaysia. So like it or not, okay, we have to follow this standard. Otherwise, Malaysia would breach the agreement and then we are no longer part of the signatory. Okay, so this is an example of Minyak Cakapa. Okay, what are those IP applicable for this Minyak Cakapa? Just to protect this Minyak Cakapa, a simple Minyak Cakapa. Simple for us now lah because it's too familiar, too customary to us. But way back then, or maybe for the person skill in the art, it's not easy to come up with that composition of the pain relief to human, or maybe not just human, maybe to cats can. So who knows? And no, we never do the animal testing with that. Okay, so the aspect of pattern is very technical in nature. Talking about the composition itself. So the composition that included in the Minyak Cakapa or the X brand universal oil, okay, for topical application is listed there. Okay, so even though we know that these are all the ingredients from Minyak Cakapa, and these are the things that okay, now we can produce Minyak Cakapa. You can try. We can try. There's even a study about this. A published paper, if I'm not mistaken, the ointment. Okay, even though they have all these things, but they're still not able to produce or replicate the same ointment of similar therapeutical effect. Okay, for the fact that the ingredients are missing, some ingredients are missing from the list. So they kept that as a trade secret. The trade secret is another important thing that we need to know. But sometimes, most researchers, maybe not IUM lah, most researchers use this trade secret as an excuse not to file an IP. But yeah, I'm not sure for what reason. Maybe there's something things there. But there's a rule of thumb on selecting all of these things here. You cannot simply, because there's so many heading in the patents law, my patent search tak lepas lah, not novel lah, everything. Let's go for trade secret. There are ways of how to steer around that. There are ways how to do some work around that before you resort to trade secret. Okay, there are certain issue with trade secret. There's certain issue with copyright, patent, trademark, and design. Okay, but we all of them in one holistic protection, and it will just elevate your invention further. All right. So this example, and this also example, I'm gonna skip this part because I think the introduction is way too long than I expected. Okay. This is Tongkat Ali lah. Okay, bioactive fractions of Eurycoma longifolia. Of course. Oh yeah, there's one more thing I need to let you know. To share with you lah. Okay. Malaysia is very aggressive now in protecting our traditional knowledge, the TK. So traditional knowledge, something like traditional Chinese medicine, TCM. Okay. Now we are compiling all our traditional knowledge. So what is the effect of these traditional knowledge compilations? What is the effect? The effect will be on the novelty of the invention that we're coming up with. If you are in the pharmaceutical company, pharmaceutical field or pharmacology, and then you'll be might be something that going to affect the R&D that you're doing. Okay, so this traditionally is a compilation of all knowledge, okay, knowingly or existingly available in Malaysia, zaman Datuk Nenek dulu ke belakang. Whatever herbs, whatever things will be compiled there. So that means that there will be lesser opportunity for us to derive the novelty of our invention based on plant compound. Okay, but what is not known there is the phytochemical of the compound from that plant, the flavonoid content of it, the extraction part of it. Okay, that aspect remains there. That means you still have to the opportunity to file a patent in that aspect. But the medical use of it, the therapeutic use of it, the prophylactic use of it, that will be subject to whatever disclosed in the traditional knowledge database that soon will be published. All right. Enough lah, that intrigue you with that. So you are triggered. You have to be aware and chana at all time, alert that, okay, there's something going on. Yes. So other than the research world that is all evolving, the IP world also evolving. So the protection for indigenous knowledge, the traditional knowledge also coming up. Okay, so when we talk, we are not zooming into each IP component. So we already given you the overview of IP. So what is IP and where this is coming from? How is it going to affect us? What are those and everything? So that is the overall overview. So bear with me. Pattern and utilization will be the last section of this. But you have to bear with me before we reach there. We need to understand each and every component, IP components that are available in Malaysia. So trade secret refer to the confidential information. So we talk about information, data, information, the information, the definition of information. Okay, there's no specific act for this, okay, but trade secret is governed by confidential information law, the common law and everything. But the information that you want to go or claim as a trade secret, okay, must fulfill all these three requirements. Number one, it is commercially valuable because it is secret. How do you mean that? And is you have to do some checking, you have to do some database checking, proprietary checking, subject matter checking. Okay, how and where to do that? You can do that at your own. You can hire a third party or agent, okay, or IP counsel to ensure that you are actually sitting on the right, or you're making decision on the right thing, that trade secret is valid. Okay, the three things. The second one, the information must be known only to limited group of person. Okay, you at the TTO office lah, and then if you have to license it out, and then you must have a proper legal instrument in place. Okay. Number three, the information must be subject to reasonable step taken by IIUM in this case to keep it secret. Okay. You use the confidential agreement non-disclosure agreement, non-competing agreement, non-solicitation agreement between the receiving party and the disclosing party. Okay, who are they? And then you need to identify. A very classic example will be Listerine composition. It's a very classic trade secret known to the world. Trade secret known to the world, but doesn't mean the ingredient known to the world. Okay. Google search algorithm. There's no patent file for Google search algorithm. People are guessing and people are trying to hack the Google search algorithm. What are they? Comprises of how many AI or machine learning, how many neural network, God knows what contains in there. This undisclosed information. But what we know so far is that the Google search algorithm is still unbeatable until now. Okay, so WD-40 and the Coca-Cola recipe. Okay, so one thing about trade secret is the misappropriation. So how to enforce? How do we tell that, oh, he or she is using our secret and to do the invention or to make up that product? But first thing, how do we know that he or she derived the information from us? How do we establish that? There is a possibility that he or she, independently derive the information. Then how do we establish a relationship that before the accusation of he or she is deriving from us? How? Oh, he or she attended our webinar today. He or she attended our talk. He attended my booth at ITEX today. That's why I disclosed information to him, to them, to her. So if you're able to establish that, okay, or maybe establish prior to that, he or she have no knowledge, and that's a different thing. Okay, those are trade secret is very, very volatile protection. We say it's kind of volatile. So be careful with that. And as much you want to push for trade secret, because no registration for trade secret at all, nothing. You don't have to go to my pool and say, hey, this is my trade secret. No, there's no registration for trade secret. Just within TTO or UM's premises. That's all. Okay, and whatever the receiving party lah. Okay, so it's kind of hard to commercialize, but it's doable. Okay, so I'm gonna skip this, the Moderna COVID-19 example. You have a question and let me come back to this. Okay, that's all about trade secret. Very easy peasy. So bear in mind the differentiation between copyright, trade secret, patent, and trademark. Because at the end of the day, that will be the objective of this webinar, to able to identify, not just identify, to differentiate. Not just to differentiate, but to appreciate what are those. Okay. So copyright, the very famous, other than patent lah. Okay, because the very famous avenue to go for Okay, not the one that you wish that you fall. So copyright concerned about literary and artistic works. Okay, more on the creative expression or creative authorship. Okay, how do you express, for example, international combustion engine earlier on? You express the internal combustion engine (ICE) by way of writing. You write it down lah, you tulis lah, comprised of this and this and this, or the ICE, and then you come up with the drawing. That's how you express it. That's how you visualize it in a form of writing, in a form of drawing. And that writing and that drawing considered as manuscript. A manuscript considered as literary work. Literary work is protectable under the copyright law. Faham? But how about the international combustion engine? International combustion engine is not available, is not protected by the copyright law. So you have to go to different IP regime. You have to file that under the patents law. But under patents law, tak lepas the novelty, it's not novel. And then you have to do your R&D lah. What, you want to change the law? You want to change this? The only thing you can change is the R&D work, the output, the deliverable. So maybe you might be doing, or you might reinventing the wheel. So somebody have done that before without you realizing it, without a proper literature review or checking, you are reinventing the same thing. So that's why I emphasize a very early or the outside the beginning of this webinar, the constant or regular or predicate checking or reality checking is very important. One patent search is not enough. One-time literature review not enough. You have to do it at all time to preserve or to ensure that there's novelty there, there's something there. Okay, that would be a patent. I will touch that one later. So example covered by the copyright law: books, music, painting, sculpture, film, okay, computer program, the source code, databases, advertisement, maps, and technical drawings. Buildings are covered by the copyright law. So the protection is automatic. What does it mean? Why we still have to file at MIPO? So the reason why the one that you file at MIPO is a voluntary copyright notification. Voluntary, there are two keywords there. Number one, voluntary, dengan sukarelanya, suka hatinya. The second keyword is notification, notify, not application. Faham? So notify, you notify, voluntarily notify that this is your copyright work. Okay. Under the Berne Convention, there should not be any formal registration of copyright. So that means that at the end of the day, so it is protected upon creation. It's like the slide now that you see on the screen and my video over here. Okay, if you wish to record this, then you have to get a consent from the speaker, to have the consent with this and this and this. So that's why you can see a copyright notice down there and the second slide of this particular session. So not just just to bring you an example how things work. Okay, same goes to your lecture note. Same goes to your Zoom recording for your lecture series and everything. So all of them are automatically protected. You don't have to file and submit to Malaysian IP Office for that. No, halas, it's only there for you. So you have to enjoy, able to enjoy. But put on a proper footer, a proper copyright disclaimer and everything. Okay. Same goes to overseas protection. So whatever are protected in Malaysia, okay, is also protected in other countries. For copyright only. Don't quote me for something else. So this is the screen that for over copyright in the context of copyright law. Okay. What else that you need to know? There's 6 categories of works eligible for copyright. I repeat, 6 and only 6. And what are those? Literary work, kerja-kerja penulisan, musical work, artistic works, film, sound recording, broadcast. Okay. So in addition to these 6, okay, the law also gives protection for derivative works. What are derivative works? Translation, okay, adaptation, arrangement, or any other transformation of the listed works eligible for copyright then. Okay, so you transform the literary work from you're adapting your novel to a script, and from a script to a movie, and you will create the casting and everything. So you you rearranging an original song using a wind orchestra to produce a different arrangement, but having a similar or identical melody or lyric. That is a transformation. Okay, so this is the non-exhaustive list of works eligible under copyright. Okay, for literary work, it covers novels, stories, book, pamphlet, manuscript. Okay, works and other writings, table, compilations, and computer program. The source code, the pseudocode, the language, whatever you use to do the scripting, will falls under computer program, which falls under literary work, which is suitable for copyright filing. Okay, musical work, artistic work, I think I skipped this lah. Okay, you're gonna have this slide later. Okay, film, sound recording, and broadcasting. So this is the definition of each of the work eligible under the copyright law. So now, since there's no registration, how can you prove the originality and the ownership? Okay, number one, by way of mailing or posting the document within a sealed envelope to your own address and keep the envelope unopened. Okay, the first traditional way of doing this. So the second one, okay, you made a statutory declaration stating the fact that you are the owner of this, and then you append or you supplement that certification with the work eligible in the copyright law before a commissioner for oath. That's two. The third one that which you are currently doing right now is copyright voluntary notification and MIPO. So you deposit a sample of your work to Malaysian IP Office, okay, or to any solicitor lah yang you nak guna, but to a depository like Malaysian IP Office, and then we do the formality checking only. There's no examination of copyright. That's why you can, it's very easy peasy, within 6 months or within 5 months, you'll get a certificate. There's no examination on that part. And MIPO will issue a certificate of copyright. Okay. So this certificate of copyright give you the formalized ownership of that copyright work that belongs to you. But there's no meaningful proof method of proving authorship. Whatever you have there, even though those produced or issued by Malaysian IP Office can be subject to any dispute. People can challenge the prima facie ownership of your copyright your copyright. So you still, this one person or interested party can still bring you to the court to for any invalidation proceeding or any dispute lah. Okay, so you need to prove and improve evidence lah if you want to prove. Otherwise, you can abandon the case lah, and then the copyright ownership will be revoked. Okay. So in your case, okay, the person who the person who created the work owns the copyright in the work. So you are the researcher, or you are the person, the author. So under the copyright law, the term used for the person who creating the work is author, bukan inventor. Inventor will be used, the term is used in the patents law. For copyright, the term is author. Sebab tu dia tak ada invention. Dia nama penulis, pengkarya, author. Okay. So initially vested in you, but by virtue of employment, your employer owns the copyright. In this case, IUM will own the copyright. However difficult that you did or you have come up with that copyright, but because of the employment, the copyright will be owned by IUM. And in the second rule will be on the commissioning work. So if a person commissions you to do the work, you have no right at all on the ownership of the work produced for the exercise. The person who commissioned the work is the one going to own the work, unless there's a agreement to the contrary. But highly unlikely there will be agreement to the contrary. I ask you to do this and this. Of course, I need the ownership of this. Why would I pass my ownership to you? I paid you, but you need to give everything to me. That's how it works lah. Okay. So unless you have that contrary lah, so that depends. That will be a separate, different story together. So what the right given and the literary work, dramatic work, musical work, I listed that. Gonna skip this. Okay. The film, broadcast, performance are also there. So out of 3 rights given by the copyright law, the third one is the one that I want to emphasize: the paternity right and the integrity right. So you have the rights to preserve your name, you yourself as author of the work. If you contributed to certain aspect or certain section of the research paper, and the next thing you know, the paper was published without your name in there, and you can exercise your right. Hey, I contributed for this literature review, so I have done so and so. Just because of your personal friction, and then you remove my name from there, so you can exercise your rights to do that. But again, try to maintain the harmony within the team lah. Okay, the second one, the integrity right. So if there's any modification of the work that result in distortion, mutilation, that adversely affecting you or your honor and your reputation, then you can exercise this right lah. Okay. Defense for copyright infringement, gonna skip this. Because we don't have to defend lah. If we produce the copyright properly, and why we have to defend? So that means we have to understand it properly, understand the law, so that we're able to, we don't have to get ourselves into that kind of mess. All right. So this is example copyright around us. Okay. Now we have covered the trade secret and the copyright. We penat nak cakap. Okay. So for the third one, industrial design. So this is the one that, I try to do some quick recap. So trade secret, refer to information that must be secret and qualify all these, all the 3 requirements. Copyright, protect on the expression part of it. Okay, the literary work and the artistic work of it. Industrial design, protect the exterior part of your product. Exterior, which means ornamental and aesthetic aspect of an article. So the term article used here refer to a piece of product. Okay, bukannya artikel surat khabar, artikel paper, no. So this cermin mata over here, kan nampak tak? Or maybe this particular stapler, nampak? Okay, this particular stapler, and now you have to look at me. So this particular stapler over here, okay, the ornamental, the aesthetic aspect of this stapler under the Industrial Design Act is called an article. This is an article. So the ornamental or aesthetic part of this stapler, okay, can be protected under industrial design. But how the stapler function, okay, how the staple being moved forward using whatever mechanism here, pattern. The name, okay, that dolphin ke whatever here, trademark. Clear? Okay. So it can be 3-dimensional and 2-dimensional. For example, shape of fork and spoon and shape of the headscarf. So the headscarf itself is already customary. Whatever headscarf is going to be this way. Okay. But what makes this this headscarf qualify for industrial design? Because of the design of the lace and the awning section of the headscarf. The lace contributes to the novelty of the industrial design. So because of the lace, thanks to the lace, so this industrial design can be registered. Okay, so if you want to file a trademark, in this industrial design, it can be anything that ornamental, or it can be anything that appeal to the eye, then judged by the eye. Okay, another example, shape of helmet and mouse, your computer mouse. Okay, so the one that you see on the screen now, the mouse is bendable. So that means if you want to use it, you have to bend it that way. Or if you settle using that, and you have to make it flatten it. Okay, I mean you unbend it lah. So the bending and unbending mechanism will not be able to be protected under the industrial design law. How it works, the flexible substrate used in the mouse, okay, to make it flexible or switch on or switch off the use of the mouse will be subject to the patent's law. The transmission and everything, patent's law. So if you say that I already have industrial design for my mouse, if I don't need file a pattern, okay, so industrial design only cover the shape, but the one that you want to commercialize is the component inside there. The transceiver, the Bluetooth, whatever wireless communication, the microcontroller, Arduino, whatnot, all everything there. So the microcontroller and the technical aspect of the invention won't be able to be protected under industrial design. I'm afraid you have to file a patent for that. Okay. So in order for us to decide which IP is suitable for this particular product, among other factors will be how you want to commercialize this. How you want to sell this product. Or you sell that way, or you sell a component of a product, you sell in that color, you sell in that brand. How? So if you still undecided, you have to make up your mind and decide which way or forward for your commercialization. So of course we can have plan A, B, C, D with the first cut, second cut, third cut. You can have a business model canvas, whatnot, but you need to make a decision and you cannot be sleeping on it for too long. If you need assistance, reach out to TTO or IUM, they will be able to help you on that. Okay, so this is the definition of article I mentioned earlier on. Okay. So the Section 3 of Industrial Design Act highlighted the non-registrable industrial design. Okay, method or principle of construction is not allowed in Malaysia. Okay, features depends upon the appearance of another article. Okay, which form an integral part of the article is not eligible for industrial design protection. So features that detected solely by function is not protectable under industrial design. Kenapa? Because the function is under the patents law. So the law, the Industrial Design Act specifically mentioned that whatever that is technical, not under Industrial Design Act lah. You have to go to a different act. So you fight lah for the technicality here. Industrial Design Act just have no power, no bite, nothing that can be dealt with the technicality part of the invention. Okay. So the requirement for industrial design, the section 12, number 1 is it must be new. So was not disclosed to the public anywhere in Malaysia or any other countries. So similar like pattern, but in the context of industrial design, it will be the designs, not the technical aspect of it. So if you already publish a housing, if you already publish the shape of your product elsewhere, in Malaysia or elsewhere, your product might not be new and might not be registrable under industrial design anymore. But in Malaysia, we have 6-month grace period. So if you able to recall, patent has a 12-month grace period, kan? But for industrial design, it's 6 months. So if it's 50% shorter than the patent lah. So if you have a industrial design, your product exposed or showcase during IMTE ke, ITEX ke, SIF ke, any lah, ada conference, even your paper ke, your website ke, YouTube ke, you had 6 months from that to file industrial design. If you have intention to file lah. Otherwise, whatever you publish will kill the industrial design registrability. Okay. And not just that, might also affect your patent letter. So at the end of the day, okay, we need to be as quick as possible in terms of securing the filing date. The filing date for industrial design, the filing date for patent, okay, but not so much on trademark. Why? Later I will tell you why. Why trademark is not, we don't have the rush to file a trademark now. Okay, that will be later lah. So to commercialize an industrial design, this is the list of the bundle of right, okay, given to design owner. So in this case, siapa? IIUM lah, the design owner. So if you want to commercialize your industrial design, what can you do to make? Of course, you have to make lah. So you don't buat the design. So what next? You have to make it, produce it, or you can issue a license and third party will use the license to produce on your behalf. So that you can enter the market and you get some return from that. Okay. So example, industrial design around us. Okay. Handbag lah, we have shape of the canister, we have the containers, Tupperware. What happened to Tupperware? Okay, we have this switch, 1 gang, 2 gang, 3 gang. We have mobile robot, Okay, if you look at this mobile robot, the shape of the mobile robot, okay, can be protected under industrial design. But how it works, how it detects obstacle, what is the path planning, what is the AI, how the image being analyzed, what type of AI being used, pattern. Okay, the name light strike on the screen may appear on the robot kan over here, trademark. Oh, you find I already have a trademark for this product. Okay, so the name only protected lah. So you can prevent other person using a similar name for that product, but you cannot prevent other person from replicating that product. What if they use the same product but use a different name? In the case, then you don't have you don't have any patent protection for that. You can just smile. Nothing much you can do. Okay, of course, there's a few things that you can take action against them lah. But the more formalized rights will be patent, okay, industrial design, and other confidentiality law lah. Okay, so we are coming up to the second last section of this webinar. Okay, but I saw a lot of things coming up in the chat box. Hold on. Oh, dah 13. Mana Miss Aisyah ni tak ping saya pasal ni. Okay, hold on. Okay, alright. From Dr. Fatmi Shehrul. I would like to ask to get the record. Okay. Okay, that would be later lah. I'm trying to pick up question related to the topic. Okay, from Dr. TC Ayat. I'm not sure this is your real name, but Dr. Ayat lah. Does applying ISBN from Perpustakaan Negara is copyright? The short answer is no. So ISBN is for identifier. So it's a unique identifier issued for that particular book or manuscript or that particular article lah. Okay. Copyright is something else. Okay. Even though you have ISBN, okay, doesn't mean that it formalizes the ownership of the copyright. ISBN just give or issue a unique identifier for that particular, for example, book. But in order for you to formalize the ownership of the book, copyright law is the one. So in this case, I would advise that I get a copyright sorted out first. Sorted out means that you either can use the statutory declaration or you register at MyPo. Of course, IUM's case, you have to go through library lah. So get the copyright protection formalized and sorted out first. Once you get it done, then you reach out to the Perpustakaan Negara or any Perpustakaan Negara lah to issue the ISBN for you. So in that case, the moment you disclose the book to Perpustakaan Negara, whoever who have access to the document lah, okay, already know that you already have protection for copyright protection for this. But as I mentioned earlier on, copyright protection is not mandatory. Copyright filing is not mandatory. It is voluntarily in nature. So you can see you have the three options I mentioned earlier on. But in short, ISBN and copyright are two different things. Okay, so they might have similar element, which is in this case the book, but the scope of ISBN is different than the scope of the copyright law, because in copyright law there's no ISBN. So ISBN is additional or accessory or not related to the copyright law. Same thing, ISBN. Okay, copyright law might be, but copyright law, however, is related to ISBN. So I would say it's it's an accessory to the copyright law. But the first thing, your right or your ownership law must be protected under copyright law first. Okay, so from Dr. Nur Fatin Farhana, Salam Zaifah, welcome salam. I might miss the point pertaining to the copyright. You said that only need notification. To whom should we notify? In this case, ada dua lah. Okay, the first one would be the solicitor. Okay, the second one is the depository. So solicitor ni the lawyer, the solicitor lah. Okay, but the one that it's being at the mass market now, the depository, which is in this case Malaysian IP Office. So we voluntarily notify dia macam ni. We voluntarily notify the government of Malaysia to give for protection for copyright through Malaysian IP Office, through MyPo. So we submit the deposition of work, or we deposit our work to MyPo under a certain form CR1 and everything, to voluntarily or at our own volition notify the government that, hey, this is my work, and then I need you to formalize this and issue me a certificate so that I can move on or move forward with the further copyright transaction, IP transaction or compensation letter. So the short answer for this, the notification should be made to MyPo.
Irfan, Cik Irfan, actually apa is our legal lah. Legal to the RMC. So I hope that Fatin, you can understand how what they call the copyright is actually work. Particularly for our case, we most of the time we will what they call notify to the MyPO lah.
Okay, thank you so much, Rafi. From Dr. Putri Azlan Megat Ramli, Assalamualaikum, Waalaikumsalam. Can we get a copyright for the process flow? The objective is to ensure that only us can do the process. Boleh ke? The process flow. So mean the algorithm, like for example, certification flow, the process flow. Okay. You can get a copyright for the writing of the process flow. So if the process flow is written in piece of document like this, for example, like this, and then you can have that copyright, this document submitted to Malaysian IP Office, and this document will be copyrighted. Okay. But if the one that you are concerned is that, okay, the objective is to ensure that only you can do the process, okay, to prevent that. So remember that the copyright law prevent any third party without your consent to use this. That means that they have the document with them, but they cannot photostat, they cannot ambil gambar, they cannot do or adaptation arrangement, doing different things. I give you a simple example. A training module. So a training module, okay, for training lah, okay, a module for training. So that module of training comprises of SOP, the teaching learning, teaching objective, the outcome, the deliverable, the whatever lesson, task and everything lah, all listed there. So that module, okay, because it is written in the form of a book or in form of SOP, in the form of a training kit. So that module can be that module falls under the literary works under copyright law. So that literary works, okay, can be registered under, can be filed under copyright protection. Okay, so in that case, the fact that you have this module training registered for example, IUM, and the person that can execute or that can use that module will be IIUM only and only. So if any trainer or if anyone would like to use the module for other than IUM, so that person need to get consent from IUM. So in this kit, okay, so if you want to ensure that you are the one who need to use that, then you need to copyright the module and you need to copyright everything related to the training. So the training might involve documentation in different form. You have the video lah, you have the recording lah and everything, and that training also involve teaching material, involve example, involve so many things. So in that case, yes, you can ensure that only you can do, can carry out the process legally. So if there's any person is carrying out the training using the module, he or she is infringing your copyright. Okay. But in this case, kena tengok balik the process flow tu apa. So generally process flow that I can get the impression would be the general process flow, the training, or maybe a simple process flow, non-technical in nature. But if it is technical in nature, that means the process flow to involve the production of graphene. The process flow to involve the combustion of biomass. That one different story. Okay. All right. So
I
I'm going.
just want to add on a bit. Doctor, in regards to the copyright, so basically all the documents can be copyright. But the thing is that if you want to get funding from the university to support your copyright filing, so that one, according our guidelines is only to allow copyright that is related to research. So we will screen it first. Say for example, if the library rejected your application for copyright, that doesn't mean that you cannot file for copyright. You can still file the copyright, but the budget will be totally from your own funding lah, rather than using the funding from the university. Okay, thank you.
All right, thank you so much, Dr. Hafiz. So we can carry on with the trademark. Okay, so trademark ni, as I mentioned, is a brand name. I try to find a correct term for this. A name tag, a brand tag. So yeah, what is the brand tag thing? So what is the definition of a trademark? Okay, so under the law, trademark is a sign. A sign itu is a tanda ataupun dalam bahasa Melayu cap lah. That's why trademark is cap dagang. It's a tanda dagang, it's a cap. Okay, so that's why minyak cap kapak earlier on kan, cap. So it's a sign. So one of the requirement is the design, the sign must be capable of distinguishing the goods, the barang-barangan, or the services or perkhidmatan one enterprise from the other enterprise. So that's why we cannot see a similar university name, IUM, IUM2, IUM3, IUM4, okay? And then now we realize that, oh, there's a IUM Technology Sdn Bhd. And suddenly out of sudden, why is it? It's not under syarikat or subsidiary of IUM. But no, actually. So with this trademark, you are able to prevent the use of the name without your consent, without your permission. Okay. But the fundamental aspect of trademark that we all need to understand is the distinctiveness. It must be, because of it is distinctive in nature, you're able to distinguish or differentiate or tell apart between these two. Okay. A classic example, okay, would be this pair of shoes that I put on the screen. Okay, easy for us to understand. With the use of 3-stripe trademark over here, we are able to directly tell that or readily tell that this shoe belongs to Adidas. Adidas, because of this very well-known 3-stripe. Wherever we go, the moment we see this 3-stripe, the only thing strike our mind will be Adidas. Adidas. Not even the name appear there, but the 3-stripe is so distinctive. The 3-stripe is so prominent. The 3-stripe is so well known that it able to differentiate or tell apart between the shoe produced by Adidas and this fella. So in order for this shoe to be recognized, then they use a different brand name. So we can see over here is Under Armour. So from here, kita nampak lah. So there's two different things. That's the point of having a trademark. But if your concern is, Irfan, our concern is the shock absorption insole. So the insole and the sole, we use a special polyurethane that we derive from a plastic bottle, a waste plastic bottle. Okay, so if that is the case, trademark is your priority number 3 or number 2. Your first priority will be patent. So we need to patent the insole, the composition or the material for the insole. But you also mentioned that, Irfan, kita punya concern pasal shape of the shoe juga. Sebab, because the design of the shoe is like this, so a person can easily put in the feet, sarung terus saja, tak perlu nak duduk tarik kat belakang, tak payah. Because of the design made this way, it help with that shoe wearing, the shoe wearing lah. So if the design is a concern and you need to file it as a design. Okay, and then what else here? So the fabric used on the shoes. Okay, the fabric is a waterproof lah, from a biomass lah, from sugarcane bagasse lah, from kenaf lah, from a biodegradable material, everything semua ada. So the fabric is intertwined lah, putting this and different layer, anti-absorption or ventilation. So that would patent lah. That one will patent. The moment we hear about the technicality, memang memang you have to go to patent law. So similarly, if you were to put another brand on the shoes, similar shoe, not identical, similar shoe, then we can tell this is Nike, this is Adidas, and this is Under Armour. So because of that, okay. So the fact that all of them have black color shoe with white sole, like it's shown on the screen, it won't prevent them from getting a trademark. It won't prevent them getting franchise because none of the thing concerned under the trademark law. The trademark law concerned about the positioning, the name tag, the brand tag, the brand name. That's all. Okay. So remember, number one, it has to be distinctive. Okay, and must be able to distinguish the goods. So the shoes here are the goods, and the other one is services. How you can tell apart between two restaurants. For example, KFC and McDonald's. Both are fast food chain restaurant, but they use a different name. Okay lah. So they're two different things. Okay, for trademark under the trademark, in the context of trademark law. Okay, able to distinguish already. Okay, so the definition of trademark, remember the term sign kan, or cap. So it can be like anything or any sign capable of being represented graphically. It's so wide kan, it's so broad. So any sign that can be represented graphically. So as long as you can visualize in graphic form or graphic-like form, that can be used to distinguish these two goods or services, then enough already. You already fulfill the meaning of sign or definition of mark. Okay. So there are actually three types, or more than that lah. Okay. But the two prominent part will be collective mark and certification mark. So certification mark, this is the one that you cannot simply use it. So you need to follow certain standard, follow certain certification scheme or rule in order to enable you to use this kind of certification mark, like Halal Malaysia, Standard Malaysia, CRIM, ISO, and everything. You not simply use it because you have to meet the certain standard lah in order for you to use it. Okay. So this is a list of examples of signs. So the signs can be traditional signs and can be non-traditional signs. Apa tu traditional? Traditional lines a common thing lah. Letter, word, name, signature, numeral, devices, brand, heading, label, ticket. They are all nama IUM, logo kat atas ni. Here. And these are all traditional mark. Ni, saya tengah tunjuk. These are all traditional mark. So the non-traditional mark is the one on the screen yang kita highlight dengan like seesaw punya motion ni. Okay. So what are those? Number one, the shape of goods of the packaging, color, warna, okay, sound, scent, bau, okay, atau wangian, haruman, okay, hologram, positioning, sequence of motion. Now people in Malaysia, any person can file this kind of trademark here in Malaysia. So if you are interested in certain combination colors or a single color, you can file a trademark for that. Then definitely, if it is distinctive enough and capable of distinguishing from from good or services from one to another, and then the trademark might be qualified for registration. But it's still subject to some other things. So the trademark registration in Malaysia is not as simple as before 2019. Okay, because of the act was revamped in 2019, so a lot of things coming up and a lot of regulations already in place, a lot of acts already in place. And if you are a trademark owner prosecuting your own trademark application, you must deemed to be aware about all of these things in place. So you have to follow the rules and regulations stated without fail. If you fail to do so, then you can apply a session of time, but we attract more costs. So you have to be vigilant in whatever communication from Malaysian IP office. They can sometimes be late in terms of sending the response or the communication to you, but there's no excuse on our side. So the moment we receive any communication from IP office, regardless, patent ke, trademark ke, design ke, copyright ke, you must attend that within certain time period. Usually 2 months or 3 months or maybe 1 month. So you must attend within that. So if you need more time, you can apply for extension of time. Okay, that will be separate cost lah. This is an example of positioning mark. So at your keyboard, okay, if your keyboard is a Lenovo brand, then you can see this is a positioning mark imposed or deployed by Lenovo to signify that this keyboard, okay, belongs to or produced or manufactured by Lenovo. Senang je kan, just put that positioning mark over there. But the placement of the positioning of the mark, the red button there, is so significant. It's not arbitrary. I mean, we can see a lot of thought have been put in there just to position that. So yeah, it can be like on top, right bottom ke, top right ke, but still that is so prominent. We can tell right away that, oh, this is Lenovo. Now we know it. This example of is combination of colors. Okay, as you know, this is a 7-Eleven, and we have example of Family Mart, KK Mart, Tiffany green, Petronas green, Shell yellow and orange combination color. So for if you're interested to find a color mark, and then you need to choose certain particular color, not CMYK or RGB color, but under trademark law, we have the Pantone color that you still specify the coding and everything. So you're talking about the green. So what type of green? Which green? And then you're going to be limited to that particular green only. So you cannot give a range. So yeah, so if you're interested in this combination color, so what of yellow, what of orange, red, which red? So which shades? So the shade need to be defined in terms of coding under Pantone color coding. Okay. So the in respect of the sound, the Lion Roar, okay, Metro-Goldwyn-Mayer is one of the famous sound mark. Okay. Another example would be Tarzan Yelling. Okay, it's a registered sound mark. Okay. And this is example of sequence of motion by Joe, the dishwashing liquid. So you can see this in the commercial or in their advertisement. Okay, how one drop of Joy dishwashing can clean up 4 plates. Okay, because of the sequence they put up there, and then you cannot use that kind of sequence anymore lah, because it's protected under the trademark law for them. Ada banyak cara lagi nak buat the advertisement commercial ni kan. So no need to use this sequence lah. Use a different sequence or a different way altogether. Hire influencer ke. Contoh lah, example. Okay, so these are the new thing that are in the law. Okay, so the conventional mark, as I mentioned earlier on, is a word mark, figurative mark, or composite mark, and these are the set of non-conventional mark: shade of packaging, color, sound, movement, aspect of packaging. If you can see here, what you notice is that all of this must be represented graphically. So for example, you have scent, the bau-bauan, because it is allowed under the act. You must graphically represent the scent. So macam mana nak represent the scent graphically? So that it can be distinctive. How do you represent the sound? So the sound, you need to describe the sound. Macam mana describe the Tarzan yelling? How do you describe the Tarzan yelling? How do you describe the lion roar? In a specific manner so that it distinguish or distinctive enough to qualify as a trademark. And that's the challenge there. Not just for us, the trademark practitioner, but for any person who file a trademark on their own to protect this kind of new non-conventional mark. Okay. Okay, so other than the first one, which is the visual or the oral of your trademark that itself must be distinctive. Okay, the trademark law require the trademark not to fall within this ambit. The first one is section 23, the absolute ground. The one is no Kautim one. So if it's the reserve word, no, you cannot trademark Agong lah, you cannot trademark the Bunga Raya lah, because it's reserve. No is no Kautim one. So the relative ground, section 24, still can be Kautim lah, but it's so relative that you need to know. So both of these grounds must be met in order for the trademark to be registered. So sometimes, okay, the mark looks so distinctive, but according to the examiner, so trademark law will attract the examiner. So trademark examiner, we see that or perceive that differently. So when they look at that, oh, it's more or less the same. More or less the same. How do you first phonetically pronounce that? How do you pronounce that? So that's what the first thing that we check lah. So what the second one, the visual aspect. It is visually similar and can cause a confusion in the public, and then we write with reject. So we have to define the case. Okay, we have to define the case. So this is different than this and this. We have to do this and this. We have to supply a lot of evidence to the examiner so that he or she can consider and allow the case to be registered. Okay. Actually, there's so many things, the trademark law. I said the trademark law is the one of the most active cases, with the most active cases of hearing opposition in Malaysia. And for your information, statistically, trademark Malaysia, the trademark application in Malaysia is about 50,000 to 60,000 application per year, compared to patent, which is more contentious, it's around 7 to 8,000 application per year sahaja. So copyright banyak lah, because there's no examination, nothing got to do, just a formality checking. Okay, so what is the relative ground? Okay, under section 24, if the mark, your trademark that you want to file a trademark conflict with an earlier mark, an earlier unregistered trademark, a well-known mark, or any other rights including copyright or industrial design. You see, so this is already excluded over there. So there's no way that they are like overlapping ke apa ke. But one thing we need to know, if the proposed trademark cannot have conflict with the earlier mark. Conflict here means that it cannot have any similar confusions or resemblance of the existing mark, whether or not it registered. So this is the hardest part of doing this thing. Okay. For us to conclude whether or not, there's no early unregistered mark. This is the toughest one. Okay, I'm not going to elaborate this further because it take longer time. I plan to go to patent very quickly after this. So this is the right of registered proprietor of trademark. Who is the registered proprietor of trademark? IIUM. So what I have a startup, I'm using a technology, I have a patent, I have a trademark filed before under IIUM. So how do I legally use that? You are, as a startup, you are indirectly a licensee to IIUM. So you have, of course, the licensing agreement, whatever. So this is where that you are authorized to use the trademark. So IIUM has to authorize you to use the trademark. So that's how the commercialization works for trademark. All right, so there are 45 classes of trademark. Okay, niche classes. Bukan nice and niche classes. So class 1 until class 34 related to goods, barang-barangan. Class 35 until 45 services. So so we need to know where the trademark will be used, or is currently being used, or was used. And what is your future use of your trademark? You plan to venture into medicine, then we need to find class 5 at the time when you decided to do so. Or you want to remain under education and entertainment services, class 41, just remain there. So the moment you pivot or you enter new zones or new use of the mark, then you have to alert yourself or IP Council to, hey, file a new, the same trademark but in a new class or new classes. So you have to do that. Otherwise, you are not protected for the field that other than the one you filed for. Okay, the trademark, not you the trademark. Okay, so this example of trademark around us. All right, so now we're here at patent. So now we already covered trade secret, copyright, industrial design, and trademark. So all these 4 components kita dah cover. So by right, at this point in time, we hope that you're able to differentiate. All right, this is a trade secret, but I cannot rely on trade secret because some information already published. Okay, then we go for trademark. But trademark only cover this aspect. How about industrial design? I don't have a particular shape of my product. I don't have housing, so industrial might not be relevant. But what I concern the most is that how the artificial intelligence algorithm behind there, okay, predict whatever radiation going to happen in the future. That one with pattern lah. So pattern covers so many things in relation to or in the context of the functional or technicality. So in as much as we want to inundate you a lot of information, these are the sections that are most fundamental that would need your full understanding on how patents work or how utility innovation. So utility innovation is governed under the same act, Malaysian Patents Act, sama, just a different schedule. Okay, but not all countries have this utility innovation provision. Not all. Some countries have. Malaysia ada. And Alhamdulillah kita ada that provision that is still enable many of us to do the commercialization. Okay. So what are those sections? Section 12. Number 1, whatever your R&D, if you want to go for patenting, must fulfill the meaning of invention. Under the law lah, not your invention. Sometimes the researcher, not IUM, always argue with me with us on the meaning of invention. Yes, you are right from the context of your research work, the definition of invention, but the law specifies this. So if you want to go for patent, we need to meet this requirement. So even though it meet the other requirement under IEEE ke, under whatever journal yang lain, but the law specify this. So we need to satisfy this meaning of invention. All right. So section 13 talk about non-patentable invention. Okay, then we go to section 14, 15, 16, whereby we're going to talk about patentability. So not all invention can qualify for patentability, especially inventive step. And that is the hardest part ever. I'll give some example, but I'm not going to emphasize or detail out the patentability here because I wish that we have solely a patentability webinar talking about the patentability, novelty inventive step. But no worry, we're going to introduce you to the patentability later. And what are the statutory exclusion from prior art? This part is where we introduce you to the 12-month novelty grace period under the law. Ingat balik, 6 months under the industrial design law, but for patent is 12 months. And then introduce section 36 and section 17, which is the utility innovation. All right. So can I obtain a patent and keep my invention secret? Boleh ke? I want to file a patent, but I don't want to reveal the information. And then I want to keep that as a secret. How? You cannot have both ways lah, senang cerita. Okay. So the short answer is no. Okay. So you must fully disclose the invention in the patent document. Remember earlier on I mentioned about the opposition? Yes. So the opposition is where any interested party can revoke or can invalidate your patent on the basis of insufficient disclosure. So if you nak simpan sikit, you want to keep some, you want to do this, that is where you're going to attract them to revoke your patent. So insufficient disclosure is one of the 4 grounds for invalidation or opposition. So the fact that you're not fully disclosed your invention might open up to the opposition or worst case, revocation or invalidation. So now we are not at that part already, you know. Last time okay lagi lah, boleh kau team lagi. But now, excuse me, Prof, Doctor, you have to fully disclose it. But if the information is not sufficient, we haven't conducted this experiment yet lah, Irfan. Okay, what kind of experiment? How is it relevant to this? How is it going to contribute to the support for your patent? This one, we talk about the synergy between these 2 active compounds. Right now, we have single compound. But the one we're going to patent will be the combination of these 2 compounds. Okay, but you have no data yet on the compound. So if that is the case, you need to immediately or quickly run the experiment to see the synergistic of these two compounds to support your claim in the patent document. Okay, so otherwise we open for public for opposition lah. Okay. Right, so patent is an exclusive right granted for invention. So if you were to look back to my 75 slides before, then there's nowhere I mentioned about invention. This is the slide number 76 is the first slide. Or let me 75 belakang tadi kan, talk about invention. So this is where it is. So if I can recall again or do some recapitalization, copyright, the person, we call it author. The trademark, okay, we call it the author. Industrial design, the person who create the work, we call it author. The patent, the person who create the invention, we call inventor. So there are reasons why they use a different terms here because it denotes or it refer or signify different scope of the person's skill in the art for that particular art. So the author might not be the inventor. So the inventor is the one who created the invention. The author is the one who prepared the write-up. So this is a big question here. Or if I only have a person, if I hire a person or my RA or my RG to help me with the write-up, does he or she qualify as inventor? While he just doing the write-up for you? You are the one who created that. You are the one who invented that. But in Malaysian culture, senang saja. Oh, tak apalah, dia student I akan tolong dia untuk bantu. But in real case, okay, in some other country, they scrutinize each and every contribution by each inventor. So whether or not they qualify to be named as inventor, or maybe you're just a writer or author for that document. So this is where the things happen out there. But we're not there yet coming up to the scrutinization of the inventorship. But somehow I foresee that we are coming to that part when it comes to the opposition proceeding. So when you're being named in the patent document as inventor, you have to defend. You are the one need to defend the invention because you're an inventor, and you cannot say that at the end of the day, oh, I'm just only this part, and then you are not as qualified as inventor because the inventor should be able to defend the whole thing. So you just have a portion of it. But yeah, because of the percentage, there's no specific requirement to be named as inventor, and you are named as person number 8 or number 7, number 9, somewhere at the back lah. So this is how we need to envision how the inventorship and ownership will take place in the future. Okay, so with patent, it gives you the right to decide how or whether the invention can be used by other, whether you want to use it for you yourself, use it, you manufacture and you sell it, or maybe you don't have the capacity to do so, and then you can issue a license to the party, and the party will help you with the commercialization. Okay, so I mentioned earlier on, to get this patent right, this exclusivity, the patent owner, in this case IIUM, through the inventor, okay, must make the technical information about invention publicly available. Bukan dalam Scopus, bukan dalam research paper, bukan dalam, not in that document, but through published patent document. The only patent document, okay, your proper patent document will be able to help you with this. Remember the opposition proceeding I mentioned earlier on, it emphasized the good quality of patent drafting. So the preparation of patent drafting is very, very, very crucial. So the lack of patent drafting, the poor skill in preparing the patent document, okay, will lead to or open up the susceptibility of the patent to opposition. So there are more loopholes in there, the more area to be attacked, and then the more fragile the patent is, and the more easily your patent can be revoked or invalidated. So in a way, okay, need to prepare the document properly, and of course it takes time. It takes time to produce the document. It's not a fly-by-night thing to produce a patent drafting. So it requires a lot of thought, a lot of strategizing in that preparation of document. So the one that you get the first draft is already have been taught way before that. So how to protect this, what aspect, what to do, and how to have a safety net, how to make sure that the whole thing is have less or no loophole together. It is important of good pattern drafting. So the example of very classic, I'm not sure, this is a Fischer-Tropsch synthesis, I tak ingat lah, okay? But it's a few converted from the cooking oil. So waste cooking oil, okay, cooking oil to biodiesel lah. But in this case kan, we always go on the basis of waste cooking oil. So we need to emphasize the conversion of waste cooking oil. But in that case, we need to identify what's the different, the waste cooking oil versus cooking oil. Then this is where the inventor will attack. Oh, cooking oil is a new one. This is a waste one. How different molecularly, structurally of this cooking oil now you're talking about? Or that one too different. How different is this? Okay. Or because it was exposed to high temperature, the structure, the orientation, this molecular, no lah kan. The structure, the molecular of the ester, whatever there in the vegetable oil altered or modified. So in order for it to use this, and then you have to tell us from the beginning, what is the real motivation of doing this? Why are you using waste cooking oil? Why are you using waste biomass? Biomass already a waste kan? Why are you using waste agriculture waste? Or because the landfilling and everything, I'm sorry, Prof. Landfilling too for commercialization purposes, pitching okay. But for patenting, that one tak laku. Or landfilling, tak laku ni. Kita have to find more technical problem to that. What is the problem? I mean, solving or saving the world is one thing, but the technicality part of it. So that means if you want to go for patent, you have to come from the angle. Okay, so the write-up that you prepared, okay, depending on the audience. So if the audience for business pitching, you have to modify it for business pitching presentation. But for patent, you're looking at technicality part of it. Okay, so the landfilling issue, there could be problem number 4. But the top priority problem, what is it? What is the problem with existing conversion of cooking oil to biodiesel? Or the catalyst is not regeneratable. Okay, how you make this catalyst can be regenerated or can be used again and again? I use a substitution, a different catalyst. Okay, where is this catalyst for? What is the yield and what is the conversion rate? So what is the requirement? Do you have a co-catalyst? All sort of things that will pop up rightly as a pattern drafter on our side, and also on your end, the critical thinking, the gangliosida, the HA. Okay, so as RA, if you are doing the final year research, or you're doing your FYP, the postgrad study, you have to crack your mind beyond than overthinking. So you have to crack your mind properly and use whatever neurons in your mind to exchange information so that the outcome is something that is intellectual and critical. Okay, so I will come to that part later. I'll give an example lah. So it's so good to able to see that and to share the information with you so that we realize where we stand and how to improve the research work that we are doing. Of course, if it comes from IIUM, we need a certain standard. Then we allow any research to do whatever they want in terms of research but there's a certain standard, there's certain bar, there's certain intellectuality, there's certain creativity need to be met so that we establish, IIUM establish themselves, the university as a research, as some university that produces not just research, but good quality research. All right, so session 12 about the meaning of invention. So the meaning of invention means the idea of inventor. Okay, this is the definition. Pay attention to this properly. So session 12, meaning of invention. An invention means an idea of inventor. Okay, an idea of inventor. So, okay, you got the idea on how to solve this disease problem. Okay, how to do this thing lah. Okay, which permits in practice. So the law, the definition requires some sort of practicality over there. Okay, must have that practicality element. Okay, the solution. okay, it must be in the form of solution. So must address certain problem. So must address a specific problem. So the keyword over there is specificity. So it has to be specific. That is where I mentioned earlier on, there's no one pattern blanket fits all. No. So the section 12 talk about specificity. You need, okay, which part of the phone that you're going to improve. So what kind of solution you're proposing? For the hinge, for the borosilicate containing the glass screen. What is it? So what is the problem there? You need to be able to specify that. The problem in the field of technology. So what does it mean? So it must have that technicality. It must have that technical character, and it must have some technical effect, a technical effect. Okay. Only then you're qualified for section 12. So at all time, if you promise a deliverable under pattern slogan, okay, you may make sure that you're always along this line. So if you detour a bit, and then you have to come back to the meaning of the invention, the section 12. So the invention can be product, can be a process. Okay. So example over here, the production of propionic acid due to volatilization of cocoa pod husk. So dual alkaline and enzymatic pretreatment was used. Okay. So what happened is that two sodium hydroxide and salicylic C type 2 are used, okay, to pre-treat the CPH. Okay. And this CPH, because of the treatment, the dual treatment, hydrolysate is produced. And this hydrolysate will be treated with glycerol yeast extract and the bacteria to produce the propionic acid. So the whole thing, starting from the plucking or the picking or the harvesting of the cocoa, and then the removal of cocoa, and only the cocoa pod husk is subjected to the enzymatic or alkaline treatment. The whole thing is the process. So what is the product over here? Is the propionic acid. Propionic acid is the product or the result of this kind of invention. So it can be the product, okay, it can be the process, it can be both of them in one patent document. So if utility innovation or UI, you must choose between product or process. You can have both of them in the claim section of the document. You can have both of them in the detailed description, but in the claim section, you have to claim only one of them. Some other unit product, propionic acid, you want to claim because you want to commercialize the propionic acid, or you want to commercialize the process, you want to claim the process because you want to issue a license to industry to carry out the process for you. Ini kena tepuk dada tanya selera, tang mana commercialization nak buat. That's why bila TTO tanya macam mana nak commercialize, kena ada this idea. This will help with the decision making, whether or not, okay, the patent or utility innovation. Maybe in this case, because it does not qualify for patent fully manner, we can have two utility innovation covering each, the product and the process. Also possible. So there are different strategy of doing all these things. So depending on various factors, that's why we ask the researcher to kindly extend your cooperation in terms of be transparent on what you want or what you plan for this invention. So the commercialization plan must already in place at the time of you pitching this product. So if you are not clear about how the future hold for this kind of product, and then how does the committee can make a decision on this? It's not easy. We're putting them in tough decision whether or not to allow this. But sometimes we have to use our wisdom and guts. Okay, maybe we're looking at this differently. Yeah, we can allow partially or conditionally. All right. So what else? Okay, this example of conversion of PET waste plastic to graphite and graphene. Okay, using liquid phase exfoliation. Alright, so the conversion can be direct graphitization or catalytic graphitization after pyrolysis and carbonation. Before you use the after that you use a microwave radiation to convert graphite to graphene. You see all of these things. If this is your invention, what are the process? The process will be the conversion from PET, okay, until graphene, or the second route will be PET into non-graphitic carbon. So in this case, if you look at the green color arrow here, there's one inventive concept. No, this one. The conversion of PET to graphene is one. And the second inventive concept is the conversion of PET to non-graphitic carbon. Under the patent law, you can have both of these things because they have no unity. So we need to ask you which one is the preferred, which one is the hero of the invention, which one? So if you say that the green color arrow, then much easier case lah. So we're gonna protect this. But again, okay, it's subject to patent search. So patent search is where the relative checking taking place. Whether or not the green color flow contributes to novelty, whether or not it has inventive step, whether or not it can be industrially applicable, whether or not in general, the process flow over here, the conversion of PET to graphene using microwave energy and catalytic graphitization is already known to the public or form part of the common general knowledge. Okay. Maybe in part, yes, the pyrolysis and carbonization is common, the catalytic carbonization is common, the liquid phase exfoliation is common. But what is not common there, the combination of three together. But the person skilled in the art don't need similar mind like you at this point in time where all the information are di hujung jari at your fingertip. You can just easily Google everything here and then you can arrive this invention. So that's what the patent law say, oh, this is not patentable. So because everything is at the fingertips. Okay, how to convert PET to graphene? Google. Or even you ask ChatGPT, they can give the whole thing. But that is the thing, form the part of the common knowledge already. So now, if you knew all the information there, or you had the literature review being done properly, you would not dare to proceed the same thing like this, kan? Oh yeah, you have to modify a bit. Yeah, graphene, and you specify the graphene, or one layer lah, single molecule. But that's a common thing about graphene. What is so different between this and that process? Must able to distinguish lah. That brings a novelty invention. So that's why the full disclosure is very, very important at the patent search stage. Okay, you cannot kedekut lah the information. Oh, the PET bottle ambil lah mana, the polarization, the parameter dia, temperature this, and this. Catalytic graphitization, we just use catalyst, homogeneous catalyst, liquid exfoliation microwave, just 700 watt. If just on the surface, the chance for you to get a patent will be 0 to none. So if you want to get higher chance of getting patent, you need to disclose more information. So the role of a responsible patent agent would be to dig into the stack of information that you gave or you disclose to us to find the patentable aspect. Worst case scenario, not patentable lah. Walaupun you bagi 300 pages ke 400 pages, thesis chapter 3, chapter 4, chapter 5, but it will be the same old, because the subject matter itself is already known. This is we talk about the patentability lah. Okay. This is too technical for this part. We're gonna have a separate session lah. If we can have further webinar after this. Okay. This is an example of air purifying curtain. Simple, just a fabric. You soak in a photocatalyst for a certain period retention of time, and you put it up, you hang it, and then that's it. You process, you pack it, and you jual. So as easy as that. And photocatalyst, after certain number of months, okay, you supply a chemical for them to do, the customer do your own photocatalyst coating on the curtain and make the whole thing purifying. The contaminant we purified, broke down and everything. So this is one of many patents out there, okay, and this one of many patents, basically, one of them belongs to IKEA lah, okay. Okay, section 13 talk about non-patentable invention. Number 1, discovery, scientific theory, and mathematical method, okay, are not allowed. Okay, are not allowed in Malaysia. Plant or animal variety or essentially biological process for the production of plants or animal tak boleh. Okay, so the idea here is that it must have a human intervention. Some human intervention. It cannot be thing or benda yang already biologically available out there. Okay. Number 3, scheme, rules or method for doing businesses, performing purely mental acts or playing game are not allowed in Malaysia. Diagnostic, therapeutic or surgical method of treatment for human or animal are not allowed. Last but not least, inventions that may affect public order, good morals or public health. Yang ni semua tak boleh. Okay, the subject matter per se lah tak boleh. But I give you an example. When we talk about artificial intelligence or AI, contohnya, for example, convolutional neural network (CNN). The CNN per se falls under mathematical method. Okay, in the context of patents law, tak boleh. Because of falls under mathematical method, therefore, CNN itself is not patentable subject matter. But how do we protect this? So the use of CNN, okay, in a practical application, for example, a method of predicting landslide occurrence using CNN. And then the subject matter will be the prediction method lah, using AI, which is one of them, which is CNN. And that one can. But if you want to claim that CNN, the algorithm per se, which is a mathematical method, which is non-patentable subject invention, subject matter, then it won't be allowed here in Malaysia lah. Okay, so it's just a tweaking of subject matter or twist it a bit or repositioning. We're happy with avoiding this section 13. All right. So section 36 talk about the rights of patent owner. So you file a patent. So what can you do as a patent owner? In this case, needless to remind you, patent owner is IIUM. Okay, and you as inventor have the rights, okay, to contributes to the commercialization of this, helping the universities to commercialize further. Of course, IUM through a TTO need your good self to help with the commercialization. You are in the field, you know where to go, and etc. But of course, at the same time, okay, so it takes two to tango. Both of you need to work together. So what kind of commercialization you're looking at? So the legal instrument, the legal aspect in place, how to negotiate, how to conclude the deal, everything. So these two or three entities must work together. Okay. So you have the right to exploit the patent, to assign mean that you dispose your rights as owner and then you outright sale lah senang cerita. Okay. Number 3, to conclude license contract. You issue a license to allow other party to use it. Okay. So this is the last part of the webinar. This is the last part lagi. This is the last part, the patentability. So earlier on we talked about how things, how patent how your invention can be qualified for patenting. So number 1, the meaning of inventions, okay, it must not fall under non-patentable subject matter. And then now we are at the patentability section. So patentability is where that we're going to check whether or not your invention is patentable under the patents law. Okay, under the patents law means it must be in the context of patents law, under the definition of novelty under the patents law, not your definition, under the inventive set under the patents law, not your definition. So you have to come through to that from that window, from that angle. So in as much as we want to fight for this case or fight for your define your invention, we must always know how the rules of the game. So the rules require this and this. And then we can attack properly and we can win. So similarly here. So remember, the first thing, the meaning of invention, it must be in the form of solution. So in order for, you take that one, so solution is done. Okay, tick, you qualify. But does it enough? No. So the law require, the patents law require, the solution must be novel. in order for your solution, your invention, your R&D, the output, the deliverable must be novel solution. So that means it must meet the certain requirement of novelty. But does this is sufficient? The patent law cakap, no, not enough. It must be non-obvious novel solution. Okay. Non-obvious novel solution. Novel solution is one, not enough. It must be novel solution. And that novel solution cannot be obvious. So it has to be non-obvious novel solution. There you go, what I mean, right? So it has to be non-obvious novel solution. So it cannot be any novel solution. It cannot be any solution. So what is non-obvious? So non-obviousness means referring to the inventiveness of invention. So it is very subjective, but I'll give you some example later. So how the non-obviousness of the invention or the solution can be killed, and the patentability can be revoked. Okay, remember this thing. So if you do the R&D and you aim for patenting, always put this at the back of your mind. Whatever invention you plan to go for, or you aim for patent, the R&D or the output must be non-obvious novel solution. Okay, right. So the Trinity requirement are listed here. Section 14, 15, and 16. So novelty is the primary requirement. So primary requirement means that we need to identify the distinguishing features of the invention first. Yang ni yang pertama. Must identify this first. What features differentiate your invention compared to the prior art, from the prior art? What are those? You need to identify that first. What components? Okay, what step? Which features? What parameters? Okay, what are those? We need to be able to identify that. That's the first, the baby step lah. So the novelty, once we identify novelty, we talk about, then we identify the inventive step. Don't mistake this for the step, the process step or the methodology step. Inventive step here refer to non-obviousness. So the invention cannot be obvious to a person skilled in the art, like you yourself, or professor, doctor, PM, doctor, semua guys, cannot be obvious to you. If you already can tell or you can guess, you boleh teka dah ni buat apa, then it's obvious. Then the student or the student, FYP, need to crack your mind, cari benda lain. That's the first cue. The first thing. If it happened, that means that, okay, the chance to get patent ni 50-50 or maybe 60-40 ni. So that means not enough yet. There's no enough criticality there. So not enough inventiveness. Okay. Kalau principal researcher atau penyelidik can easily guess, what more orang lain kan. So that is your first. I always say this, share this with a group of researcher. So there are 5 of you in a group. So I mean the principal researcher plays the role to make sure that whatever idea, yes, we welcome any ideas that the FYP ke, the student ke, the master ke, the PhD ke, but you are the gatekeeper to make sure that whatever idea filtered through, for example, this requirement, okay, inventiveness, okay, what is this? So we have to follow this and this and this lah. Okay, the third one, industrial applicability. So this is the flow of how patentability is determined. Okay, the first one, if there is no novelty in the invention, means that it's totally identical with the prior art or with the existing technology, and right away it's not novel. Okay, but if the invention has novelty features, we will consider the inventiveness of an invention. If there is no inventive step, then we're going to opine for utility innovation protection. Okay, but if there is novelty, there is inventive step, and there is industrial applicability, then we advise to go for patenting. So the Trinity requirement is here lah. Okay, but mostly I would say that based on the statistic cases lah yang ada kan, So mostly landed here, utility innovation. But it does not mean the end of the road. You still can supplement more information to back up or defend your invention at the patent stage, a patent search stage. This is where the importance of discuss with your patent agent, discuss with us. Okay. So what information you left out during the initial disclosure, only now you want to include in, or maybe we already have completed the writing, please Irfan consider this information, see whether or not we can have the inventive set. But in order for us to help you, you need to able to supplement or furnish the relevant documentations lah. Okay. If just a repetition from the initial disclosure, the chance is 100% no lah. So we maintain our opinion. Because at the end of the day, the same process will be made by the patent examiner at the patent examination stage later. So at this patent stage, we still can counting, okay, we can do this and this. But at the time of patent examination stage over there, there's no way for you to counting anymore. There's no way. So whatever bullets, whatever things that you have, you must full disclosure at this stage, at the patent search stage. Alright. The novelty part ni dia panjang tau, this part. I try to do very briefly lah. Okay. So what I can say is that it's very simple. Okay. The novelty is compared against a prior art. Okay. And novelty talk about anticipation. So whether or not your invention is anticipated by prior art. Okay. So the question here is that what is the prior art? Siapa prior art ni? Apa ni? Kat mana? So what matters comprise prior art defined in section 1412, 14 bracket 2. Okay. Number one, everything. Prior art includes everything disclosed to the public. Every single thing. Everything. Disclosed to the public anywhere in the world by written publication ke, by oral disclosure ke, by use ke, or any other way prior to your patent filing date. So that means everything lah. Okay. So in order for your invention to be novel, if this is the prior art, you must have that new element over here. This new element contribute to the novelty of your invention. Understand? Huh? Okay. Yalah, it's not fair lah. I mean, it's already a prior art. And you want to patent the prior art. It's like you are inventing the wheel. It's the same thing. And highly likely you can qualify for that. Alright? So that's an analogy for that. So basically, the novelty require at least one distinguishing features. So whatever prior to your patent filing date, I repeat lagi sekali, prior to your patent filing date. Bukannya and not that prior to your submission date to TTO. So your submission date to TTO through the system kan, for example, is not the cut-off date. The cut-off date is the filing date and MIPO. There's only one date, statutory date lah. Okay. So whatever prior to that will be considered as prior art that is valid or qualified to destroy or to prejudice or to be considered for patentability purposes. Your thesis publication, the US patent lah, your own publication in general, this is where the most cases are. Okay. Or the expo or the competition. So everything. Okay. But the law, patents law in Malaysia is so generous. Okay. We still maintain the statutory exclusion from prior art. So that means if you disclose or you accidentally disclose or you subconsciously disclose or you're not aware, but you cannot say you're not aware. You attended this webinar already. You attended this webinar means that you're aware that, oh, there's 12-month grace period. So yeah, we cannot do that. We have to sit down with TTO, the Hafiz and team and see what we can do because we publish later, but the committee sitting later. So how do you go about it? Sit down, talk to them, communicate with them. There are 3 scenarios. Number 1, the disclosure by you. Number 2, disclosure through abuse of right. Number 3, medical use exception. So number 1, we call it a 12-month novelty grace period lah. So you disclose this information to the public. Okay. So within 12 months from the first disclosure, okay, you have to file your patent application so that you can preserve the novelty of your invention. despite the disclosure they have made. So the effect of this 12-month novelty grace period is that as if there is no disclosure done by you before this. There is maybe close one eye lah, tutup satu mata. Okay lah, tak apa, jalan. Because the law permits that. Ada the exclusion here. So number two, disclosure through abuse of right. Ini sama jugalah 12-month novelty grace period. Number three, medical exception. Ni ada, kalau ada soalan ni saya akan jawab lah. Okay, so the scenario ni macam ni. We simplify the whole thing so that we can visualize in the form of illustration. So scenario number one, you disclose your invention on the 13th of November 2023. The expiry of the grace period 12 months from that date, which is today. Okay, 13 November 2024. So because of the today's webinar, thanks to TTO, the Hafiz and team, okay lah, we decided that tomorrow we submit. But remember, your time window or the grace period ended already yesterday. Only tomorrow you plan lah nak approach the TO. But no worry, even though you have disclosed, okay. So in this case, I explain first. Then in this case, the patent application you file at the patent search stage, okay, your novelty will be destroyed because of your disclosure on 13 November 2023. But that is not end of the road. You go to TTO, you submit, and then you disclose the whole thing. Oh, I'm sorry, we already disclosed the information, published paper, this and this and this and this and this and this. But what we're going to patent is something else. So the something else is this, and this. So that means you must take extra miles or extra effort to explain the differences between the one you have disclosed and the one you're going to go for patent. Yang ni. You have to go extra miles lah. If you disclose the same thing and the same thing here, the chance will be 100% not patentable. Take the effort, you ada RA, ada RG, dah habis ke, dah belum grad ke, minta mereka, mai tolonglah submit dia ni according to whatever we want. You need to differentiate. So if this is the same thing, not patentable after the time window. The scenario number two, the 12-month grace period, you file a patent application yesterday before the expiry of novelty grace period. So what the effect of this is, the disclosure made by you here will be disregarded as prior art. So that means as if there's no disclosure done by you prior to 12 November 2024. Okay, so in a different scenario, on 11 November 2024, XY filed patent application for similar invention because the disclosure made by you. So now your patent application is not now, even though the disclosure by you here can be disregarded as prior art, but this fella over here can kill all your novelty because he come first. He came first, he filed first. He filed the patent application a day before you did. So that means this is qualified as a prior art to kill the novelty of invention. And your patent definitely will be void in novelty, not novel, because of him. Okay, so scenario number three is the most advisable or ideal scenario, even though not at all cases lah. Okay, so 13 November 2024, today you file a patent application, and then in the day, on the day itself, you want to publish pun dipersilakan lah. Okay, you want to do anything on the same day, dipersilakan. So it's not a big issue because you already secure a patent application. But not the other way around. So the other way around akan jadi scenario number one. But if you file patent first, akan jadi scenario number three. But if you publish first, it becomes scenario number one or number two. Okay, so even though it is a dilemma, but I would say it's a very clear cut on the way forward. Even if you have to hidup mati lah, you terpaksa juga disclose or file publish the paper. Remember, you still have the 12-month grace period. That's why I call grace period. Grace period to file a patent. And cannot lah after a patent, after your paper published, you're so happy. Okay, I got my paper published. Yada. Oh, you forgot the clock start ticking from that point, and you came later after the 1 year. Then it's a waste opportunity lah. Alright. So this is these are many reasons why we have novelty grace period. Okay. The inventive step. Ini panjang lah nak cerita, but I try my best to explain in the simplest manner. So remember, once we identify the novelty, okay, the second requirement, which is the second primary requirement, the first primary requirement, the second primary requirement is inventive step. So inventive step talk about your obviousness. Your invention cannot be obvious, even though it is novel, but it cannot be of the novelty features of invention or the invention as a whole cannot be obvious to the person's skill in the art. Okay, so let's say the distinguishing features of your invention is the selection of temperature at 70 degrees Celsius. That's all. The other prior art used 90 degrees Celsius, and you particularly use 70 degrees Celsius, lower the heat, and then because of the heat was not disclosed elsewhere in the prior art, the selection of temperature at 70 degrees Celsius contribute to novelty of your invention. Okay, now we're going to bring this temperature of 70 degrees Celsius to inventive step test. How is this selection of 70 degrees Celsius is not obvious to the person's skill in the art? If I were, dia akan keluar di scenario. If I were the person's skill in the art, the existing temperature known to me is 90 to carry out the reaction at 90 degrees Celsius. But there is a constant effort on reducing the temperature, and the lowest one reported was 80 degrees Celsius. So from 90 to 80, somewhat that range already known. But we did 70 degrees Celsius. Because of the possibility of routine try and error or workshop improvement or substitution, okay, by the person's skill in the art, there is high chance of lowering or reducing the temperature further to 70 degrees Celsius by way of experimentation, and without inventive effort, a person's skill in the art, he or she would be able to arrive at your invention. If that is the case, the patents law look at that as novel but not inventive. So that means that just a matter of routine trial and error, a person's skill will arrive to this temperature later, 70 degrees Celsius. And this is where that if you think that highly unlikely 70 degrees Celsius is possible, then we have to give evidence. We have to give the proof. We have to put up whatever the data required to support our claim that it is not a routine trial and error. Well, you cannot simply say from 90 degrees to 70 degrees just like that. And then you have to prove. The burden of proof is the inventor to prove that it's not simply 70 degrees Celsius. So we have to do this and this and this and this. Okay, then what is this and this and this? They have to disclose. So it's just, we have to go beyond parameter manipulation. From a patents law point of view, if it involves purely parameter manipulation, sama ada pressure ke, temperature ke, time ke, velocity ke, whatever parameter lah, that we consider as not obvious to the person's skill in the art. I mean, just put yourself in that person's shoes. What else can be done other than parameter manipulation? You manipulate temperature, this and this and this, combination of this and this and this, microwave range of this and this and this. What else is there? So if your research involves parameter optimization, you might need to think about it again to supplement a stronger critical methodology to your research. Parameter optimization is one thing, but crack your head a little bit. What else can be done here? Okay, so that's the obviousness lah. Okay, so the last part, not the last part, I promise you, this is the last part. Okay, utility innovation. So I mentioned earlier on throughout the presentation, okay, utility innovation is a part of the Patents Act, okay, under schedule number 2. Okay, it meets a lower level of patentability criteria. So remember, patentability criteria or requirement, there are three. Okay, novelty, inventive step, in industrial applicability kan. So now for UI, so lower tier of protection, which is have to meet that requirement, lower lah requirement. What is meant by lower? Take a look at this comparison table. So for patent, novelty, inventive step, and industrial applicability are must. Must. Okay, and you have to, the invention need to meet all these Trinity requirement, patentability requirement to qualify for patenting. Okay, so the patent allow for claiming more than one claim. So more than one claim means that we can claim product and process or more in one single patent document. What is the effect of the claim? The claim defines the scope of protection conferred to you as a patent owner. So in a nutshell, the more claims you have, okay, the higher or the bigger the scope of protection given to your patent. Okay, and it reflects the strength of the patent, which will reflect the value of your patent later. Okay, that's one. That's number two lah. Number three, in terms of patent protection, patent right, we give you 20 years. Nah, ambil 20 years. Dah exploit within 20 years. Okay, that's the number three. So how it differ from, how utility innovation differ from your patent? Utility innovation, because of lower patent, lower criteria for patentability, okay, it cannot meet the inventiveness, meaning that remember the patent must be a non-obvious novel solution kan. For utility innovation, it's an obvious and obvious novel solution or novel solution saja. Okay, it fails to meet the non-obviousness or the inventiveness of an invention. Okay, so because of that, we advise to go for protection under utility innovation, still under the patent side. What another difference is on the allowable claim. UI allow for only one claim, whether either it's a process or product. You have to choose. Or if you want to cover both, you file 2 UI applications. Okay. All right. So the term protection for UI, okay, unlike patent right away 20 years to you, UI give you first 10 years. If you want to use after 10 years or more than 10 years or before the expiry of the first 10 years, you need to file statutory declaration to extend for another 5 years. So if you want to use further than that 5 years, you need to file another certification for extension to another 5 years. So basically 10 plus 5 plus 5. So between patent and utility innovation, the patent application can convert. You can convert patent to utility innovation, or you can convert utility innovation to patent, but we attract costs. So there are costs need to be made or to be paid lah. Okay. So this is the simplest form of patent prosecution timeline in Malaysia. So the first thing, of course, the due diligence. After due diligence being made, then we file, we prepare a patent draft and the patent filing. So this is where the prior art will be considered at the time of filing.
We have another 20 minutes left.
Okay.
Yeah.
So basically, once we have filed a patent application, the clock starts ticking, and then the ticking where you have only 12 months to go overseas. Not you lah, the invention. So the patent can be extended, or the patent / UI can be extended to overseas by way of these 2 routes. Route number 1, direct filing into the country of interest. Route number 2, you file a PCT as a transit, and later you file in the country of interest. There are 2 phases here at the PCT level. So you must do that within first 12 months. So after that, okay, within the 12 months plus 6 months, which is 18 months from the filing date, the patent will be kept confidential. Okay, no examination will be carried out during this 18-month period. Tak ada examination. So that means you cannot expect the examination report or the patent to be granted within the 1.5 years or 18 months from the filing date. This is not just Malaysia, but some other countries applies the same thing. So the 18-month confidentiality period or cooling off period, and nobody knows what IIUM filed within the last 18 months. Nobody can check that. This is very confidential. No publication will be made. So after 18 months, okay, it will open for public inspection. Okay, so public inspection can use this for third-party observation. They can submit the observation to MIPO, whatever document, whatever the observation pertaining to the patentability of the invention. So they can submit lah. So the examiner will consider whether or not it qualifies as prior art, and then we conduct the examination. So the fastest way for you to get a examination report from MIPO, from the examiner, is within 2 years. 18 months plus 2 months, or within 20 months. Okay. Okay, so basically within 20 months, you can get the first examination report from MIPO. But in order for you to qualify for expedited examination, there are certain grounds. Ground means that it has to be green technology, the commercialization taking place, the infringement taking place, and submit in the form of statutory declaration, pay extra 2,000 ringgit plus to MIPO, and then they will carry out the examination for you. Then we issue examination report, and we have to reply, or if it is clear, the patent will be granted. Or you also have the chance to convert to UI from patent to UI at this stage, or at any stage during the pendency of the patent application. Okay, so there are other type of examination, substantive examination, which is a normally elected route by the universities. Modified substantive examination can be applied if and only if you have a foreign corresponding patent application. So for example, you find Malaysia and later you find the US, or maybe you find the US, later you find Malaysia. So you have corresponding family in other countries. So there are 5 recognized countries in Malaysia: US, China, Japan, Korea, and Europe. So if you file any of these countries, the prosecution in these 5 countries way much faster than MIPO. So they probably reject or grant your patent way much earlier than MIPO. And MIPO will use whatever result here in Malaysia patent application. Or if it is granted in the US, you can bring it to Malaysia and request for a modified substantive examination. The fee is slightly cheaper, but the requirement for documentation is way much higher. You need to get a certified true copy of the US granted patent document, bring over here in Malaysia and submit to Malaysian IP office. We have a different way of different examination route, which is patent prosecution highway. So this PPH involves cooperation between IPO patent offices. We have cooperation PPH with China, we have PPH with US, Europe, we have PPH with Australia, if I'm not mistaken. There are 4 or 5 PPH ongoing right now. So PPH is where the examiner, between examiners in these 2 patent offices, share the resources. Okay, so if say that we want Malaysia examiner to use the European patent examiners resources, then we can request under PPH. We cut short a lot of time, and the patent be granted earlier. But all of these things, okay, must be requested within the timeline. So once the patent is granted, you have to pay the annual fee. And I mentioned earlier on the post-grant opposition. So once your patent is granted, okay, we open for post-grant opposition for 6 months. So you granted today, and then the notice of publication, the date of publication notice of grant issued in the IP journal. That is where your post-grant opposition period started. So the 6 months allow for any interested party to oppose, to revoke, to invalidate IIUM's patent granted by MIPO. So if there's no opposition, and then the patent continue as usual. Okay, post-grant opposition proceeding is before MIPO. Even you have passed the period of post-grant opposition proceeding at MIPO, you still can bring the case to the court, okay, under different way lah, okay, not before MIPO. So yeah, that's all, okay, for today's webinar. Okay, the key takeaways here is that number one, with the sharing, okay, with a simple sharing, that you are able to, number one, have knowledge or in the know of what is the secret, number one, or what are type of IP components, okay? Remember the umbrella I shared with you just earlier on, okay? We have patent, trademark, design, copyright, okay, geographic indication, their design of IC, plan, right, production, trade secret. How are they differ from one to another? What type of protection given, okay? What type of rights given or conferred to you as a patent owner, trademark owner, industrial design owner? What are the limitations of each IP component? And being able to differentiate or appreciate all these IP components available or existing in Malaysia, we are better positioned to strategize the IP filing for your invention, and also that we affect or we influence the commercialization strategy of the whole thing. Okay, so it's like Lego lah. So Lego, in order for you to build up further, you need to build the foundation first, and with that foundation, you have to put another block, another block, another block, and that's how the things will be materialized. So without the first block, there will never IP. The block, the first block is intellectual property lah. Without a proper block and then without proper foundation, you are not able to, stack up further Legos on top of it. Okay, so this is where also we need to understand the differences between patent and innovation. And despite the lower tier of protection under innovation, both of them, okay, both of them can be used for commercialization. Okay, there's no it's like sibling cousin thingy lah. Okay, so in this case, I think KPT already recognized UI, and even though it is UI, okay, it still can be used for various IP transaction. And if you feel if your concern is on your KPI or the way of bringing this forward to the industry, then you have the impressions of this is UI, not patent. I think we take two to tango, and then we have to educate the industry as well that this is the thing that we go forward. At the end of the day, whatever we have under patent, okay, similarly, or even if not all, we convert to utility innovation as well. Okay, so and one last thing that I want to share in the research journey, okay, is always be critical in things that you do. So we can avoid overthinking on something else that's not really matters to the hakiki or the one that we do, but be critical in selection, in picking up the topic or the research for your R&D. Remember, it's taxpayer money and it's amanah, and then we have to go to bring something that is beneficial to the society. So it started with us it started very at a very early stage. Whatever we do now, the research that we are putting in or the effort we're going to put in through later must be able to be translated back to the society, okay, in whatever way, in various way, okay, be it economic impact or financial impact or social impact macam-macam, but be critical and be creative as possible. Be practical in remember the practicality part of it, and also we have to be realistic. So in this aspect, okay, always do the checking. Always do the checking. It is iterative process. You cannot do one time and that's it, halas. No, you have to do iteratively, checking and checking. Okay, so I think that's all from me. I'm happy to take up questions. Let me see the chat box. Okay, from Dr. ZR. If copyright infringement is found, what can be done to protect it? And what if the copyright is commercialized by other people without the copyright owner consent? Okay, the first question, you can look at the chat box. Yeah, it appears to everyone. If copyright infringement is found, what can be done to protect it? If there is any infringement, the first thing you need to do to gather the evidence, okay, and then check on the background of the infringer. Who is this person and how is this related to this work? Whether or not he or she could have independently came up with that copyright work as well. We have to check all those things first. Okay, so once we identify or we have conducted the background checking, due diligence, KYC, whatnot, okay, how to enforce your right? If it happen that there's no way for this person to use this, he or she must have gotten it from my work. So there's a clear-cut infringement that he's got it from me and leaked out from my site, and in this case, without my consent. So you can enforce your right. Okay, you can do cease and desist letter, you can send warning letter, okay, you can do so and so. And before you do that, you must make sure that you already establish your ownership over the copyright works. So the establishment can be done by 3 ways, as I mentioned earlier on, but the easiest will be the submission to MIPO, and then you are the you will receive the certificate of copyright for the work that you file at MIPO. Okay. And the second question, what if the copyright is commercialized by other people without the copyright owner consent? In that case, that will be a clear-cut infringement. Okay, and the definition of copyright owner here need to be tied up with the employer. In this case, IIUM. So if the copyright, okay, was infringed or is infringed by any third party without the IIUM consent through the TTO, so that means in this case, you have to alert TTO to take a proper action, whether it's legal or non-legal, to warn or alert the person that they are infringing that, and give them certain number of days, 14 days are usually, to come back to you and then or remove or dispose whatever material they have and declare that non-infringement, yada yada. And that involves the legal aspect, which is the enforcement part of it. All right, so I hope I answered your questions. Now we go to another question, Dr. Rosmina Zwin. Can we apply, the question is, can we apply for trademark for logo design for society club, not enterprise, or copyright is multiple? Okay, the first question, can we apply for a trademark? Can we apply a trademark for logo design for society club, not enterprise? Yes, can. Not necessarily. The enterprise that I mentioned earlier on represent entity. So the entity can be society, club, association, can be enterprise, can be non-enterprise, can be organization, can be anything. So the short answer is yes. So the second question, or copyright is more suitable. Copyright won't be able to protect the logo in this case if you want to use it in the course of trade, or in this case the society or club. So between copyright, okay, for a logo, in this case, for a logo, the most relevant IP protection will be or is trademark. Okay, so copyright is the not so relevant lah in this case, not so relevant. But you can file a copyright for the documentation of the logo. You can, in the form of manuscript, in the form of piece of paper, or the animation of the logo, or animated logo, animated logo, you can file under copyright lah. Boleh. But the most relevant will be trademark lah. Okay. So from Dr. Fatmi Shehun. Okay. Now. Okay, so last question from Dr. Said and Amir Faiz. Is publication of research finding in Malaysian or international journal considered as first disclosure? The short answer is yes. Whether or not it Malaysia-based research, the journal or international journal, the definition or the provision provided for the definition of prior art is everything disclosed to the public. So there's no caveat provision restricting only to Malaysia or international journal. Regardless, as long as made available to the public, then they will be considered first disclosure. All right. So any other participant who have questions other than those in the chat box, you feel free to unmute your microphone, introduce yourself, and then share your question. Oh, there's a follow-up questions from the side. Or is there any other way? Okay, so the follow-up question was, so as the example given before this, if the first disclosure is more than 1 year, cannot apply for patent, or is there any other way? If you come after the 12-month novelty grace period or time window, okay, what will happen is that at the patent search stage, the patent agent will be able to find, use or regard your publication as a prior art. So when we compare again whatever had been published in the prior art versus the one that you plan to file patent for, and we are not able to produce or derive any or identify any novelty features from between these two documents, then we give opinion that there is no novelty. So when there is no novelty, we give second opportunity to the researcher to rebut the report. The rebuttal can be in the form of supplementation or furnishing of further technical information, and or you submit additional data, technical data to support the patentability of the invention. So that means it's not totally knocked out now. So it's still you are still given this opportunity to rebut. Okay, so is there any other way? One, as I mentioned, to rebut and to sit down with a patent agent and discuss, or maybe we got to pay visit to your place and you showcase or you demonstrate how things work. Because sometimes what we observe is that the product dia tak terzahir dalam writing. It's not properly spelled out in the form of writing. So the product is there, but the one in the written form does not fully reflect the product. So if you have videos of the product, if you have photo or images of the product, other than FASM images ke, FSTR ke apa ke, but just apply so that from there, the agent will be able to pick up and see what are the aspects that's possible to go for patent. All right.
All right. Thank you. Thank you, Ms. Irfan, for the insightful presentation and also the participation for the Q&A session. And it looks like we have covered all the questions. Thank you once again for the sharing, Ms. Irfan. And thank you to all our participants for joining us today. We hope this session has given you a clearer understanding of intellectual property and its importance in innovation and commercialization. So before we end, a gentle reminder to all participants to log into the iAttend link provided and to fill in the evaluation form as well. This is important for MM staff to ensure that the CTD points are credited accordingly. With that, we conclude today's webinar with Tasbih Ghafaran Surah to us. Assalamualaikum and have a wonderful day ahead. Bye-bye.
Assalamualaikum.